Still there.
Still there. Still working. For last
And you are 55 years now.
but since 2002, I am working.
So very good, you continue.
And I'm not paying for any entry one.
No, you are, please come to the earlier writ petition order.
Yes.
So this notification, this employment notification was on 2015.
Yes.
I see.
Say, similarly situated person, Pushpa Rani Biswas, she also participated.
In this
Advertisement. That's what I'm just submitting. Kindly come to the chart I prepared.
Yes,
very
page.
clear. Page number 21. Now, you kindly see, appointed on 2002 in the place of craft instructor music. Same Pushpa Rani also. All documents are there. Then order on 15/9/2005, an order was passed by the tribunal in going under this. Same order was passed.
What was the order?
Directing the, I have written here, directing the authorities to consider the case of the applicant in the line of now. Applicant filed original application bearing 66 and the line of tribunal after hearing the parties on 10/12/2008 directing the authorities not to replace the applicant till the regular selection is made.
Where did you read that?
Paragraph, page number 22, second paragraph, second row. Here comes the difference.
First row is Augusta Kazur, who is the
First column.
first column, yes.
Second column is Pushpa Rani Biswas.
Very good. Now here, Augusta preferred an OA 66.
66.
Challenging the order passed pursuant to the earlier order of the tribunal.
Correct.
Now, in that was disposed of by an order dated. This was disposed of granting this that your case will be considered in accordance with the recruitment rules, but they cannot remove you till a regular employee comes. This was the
This was the order on. This was the order on 10/12/2008. It's very important. Now,
This was the. This order was of 10th of
December 2008.
December 2008. Yes.
Now, Your Worship, Pushpa Rani Biswas, the order was passed on 30th January 2008. 1 year, approximately 1 year before.
30th January 2008.
Yes. In that, Your Worship, the order was, the direction was given to the authorities to consider the case of the applicant and other craft instructors against the sanction. Consider for regularization. That is of the order of 30th January 2008. So this petitioner, Your Worship, we cannot expect that every craft instructor will know what is the order passed in the case of the other craft instructor. But it was a duty of the authorities to place before the honorable tribunal that this was the order in the earlier matter. Same order should be passed, or else we will argue the matter. So this was not disclosed. And the tribunal passed an order that till the regular selection takes place.
Please show us that order.
30th January, Your Worship, or 10/12.
10th of December 2008.
Yes. Yes.
That is quoted in the order impugned.
Yes, sir.
243.
That is quoted.
So on going through the documents, we find the applicant was given opportunity to take part, but she could not come out successful.
That is incorrect finding because she was brought into the category of ineligible candidates.
No. After this order was passed on 10th of December 2008, what was the direction? That you may be considered against the. Your argument was that he may be considered against the said vacancy. Now, regularization was denied. However, it was said, in view of the legal position, no direction can be issued to regularize her. However, since the appellant is continuing, in this she should be allowed to continue we dispose of this, the direction be given a chance in the next selection when he will be notified she is otherwise eligible. Now this now when did the notification come? This order after 10th of December 2008, the next notification came in 2015. So by this order has given that he will be given a further chance in the next selection when it will be notified.
But your lordship, they
Just a moment. Now this 2015 notification which came, in that you participated.
no, your lordship, because I was considered to be ineligible.
You were
Due to
considered
overage.
due to overage.
But
That
at the same time, now kindly consider looking to the case of Pushparani. That is important.
Madam, you are bound by this order now. You cannot go beyond this order now.
Similarly situated persons, the tribunal is required.
That you ought to have argued, Mr. Madam.
Lordship, people will know. I was appearing for Pushparani Biswas. That's why I came to know that this order was passed earlier in the similarly situated persons.
No, this order is plain and simple. They will consider you in the next recruitment process. That direction is there.
10/12/2008.
10/12/2000. Now the next notification, they started this by the fresh notification which came on.
In 2015.
No, that has been. Next notification came.
The order says provided she is eligible.
We will come to that. Give us the notification date.
20th.
Yes, it is somewhere there. 15 September 2000. No. It is there. It is there.
20th April 2015.
Just
20th April 2015.
20th of April 2015. That is internal page 9, that after the courier. Now this
177.
one,
Page 177.
170.
7.
Madam, you are bound by this order.
May I submit to lordship?
Now let us clarify what was the direction that we dispose of this application. With a direction, applicant be given further chance in the next selection as and when it will be notified, provided she is otherwise eligible as per the provisions of the recruitment rules. So this rider you do not fulfill. However, the court said still new appointment is made, you will not be disturbed. So if you are continuing, madam. Question of regularization at this stage does not arise.
Lordship, may I speak? Lordship, may kindly visualize the situation. That
You cannot take us to the earlier aspect of it.
Lordship says, Lordship, 30th January 2008 order is not only for Pushparani Biswas. It was all for all draft instructors.
Why didn't you argue, madam?
Lordship, that's what I'm submitting, Lordship,
And that order also of 2008, madam.
May I? Can we imagine, Your Lordship, that every order will be known to the candidate, Your Lordship? Every candidate? Can we know that? It would, but authority is not priority.
Anything can be done, Mr.
Then, my lord, there will be no finality, my lord. Every time it cannot be, my lord. Even a wrong order is binding between parties, my lord.
Making submission, Your Lordship, I will facing judgment to that effect, Your Lordship, about similarly situated persons and
Even if we accept that, Miss Nath, what was the direction in their two matters? That you considered them under the sanction post in consonance with the rules.
Instructor similarly situated all craft instructor. That is the order of 30th January. That's what I'm submitting.
So you are not they participated in which selection process?
After that,
2015 selection process.
that is a peculiar thing what happened. In
Another notification came.
No, Pushparani Biswas, another thing has happened. In between what happened, Your Lordship, she was not considered, she was rejected. The case of Pushparani Biswas was rejected even after the order of 30th January. On the ground that earlier she participated, sometimes in 2005, she participated in the selection process, she failed. So she cannot be recognized. That was the order passed by the authorities. 23rd July 2008. Then she challenged that particular order again before the tribunal. This is what, Your Lordship, I am submitting. Kindly Just give me some minutes, your
No, no, we are giving you, we are not, it is your case, we will hear you, there is no problem with that. So tribunal passed an order on 23rd July 2008,
authorities
passed an order on 23rd July 2008 saying what?
saying that she has already paid Pushpa Rani this.
Earlier participated, now you
And now we cannot do anything.
very good. But we cannot allow her to participate.
Yes.
That was went up in High Court.
We cannot regularize. The point was regularization. We cannot consider her for regularization because she has already failed.
Then what did the High Court say?
Then she again filed an original application.
Hmm.
Pushpa Rani this one.
Hmm.
Pushpa, the tribunal said, what you have followed in other cases of craft instructor, that was the case of Manjula. One Manjula was there. You must follow the same for Pushpa Rani Biswas also.
Hmm.
Though she failed, the tribunal said you have to follow the same decision which has been rendered in the OA 55 AN 2007.
55 N is Pushpa. OA 36 is of Manjula.
No. That is OA 176 AN 2009.
Order is at page 230, this.
I can show the orders, Your Worship. I can show the orders.
No, you have taken us to page 22. Pursuant to the direction of Pushpa in the second column, an order of 30th January 2008, she was rejected on a plea that she had participated earlier. So that went to High Court. High Court said,
That went to the CAT.
Cat said that whatever process you have follow in this case of Pushpa.
Yes, whatever process you have followed for other craft instructors,
Hmm.
in OA 55 of 2007, one decision was there. In OA 55 of 2007.
That is of Pushpa. When 55 of 2007 is Pushpa's application.
Yes, because in Pushpa, there was a direction to consider the case.
Hmm.
So despite failing in the examination, you should follow that decision. The tribunal has said. Kindly see the judgment. 55.
Page.
Yes.
Page 230.
Okay, last.
I think at part.
He is bound by the order of the ROA.
Sit there, wait, pause. Just a minute. I'll just shoot. Sit there, wait.
Pushpa was ultimately regularized.
Ultimately, there was, Your Worship, that order thereafter, Your Worship, it was not complied with. That order was not complied.
No, they went to SLP order.
They passed another order on 29th November 2012 and rejected the candidature.
That was set aside and tribunal directed you appoint him at par with Manjula.
And she had.
That was preferred, SLP was preferred dismissed. So why didn't you tell these facts to the earlier court?
That's what, Your Worship, I appear.
But how can we review that order, Madam
I
Kaisi?
am only saying, Your Worship, to remand the matter back to your tribunal to consider all these.
Madam, what you are wanting is regularization
Yes.
and similar treatment with another person who is similarly situated. This is what you are wanting from us. This was also because this order SLP dismissal. When was the order passed in 10th of December 2008?
The order which was passed was actual order was 30th January 2008. That was the actual order where the tribunal not only directed to consider the case of the petitioners therein, but also directed that all similarly situated craft instructors should be considered for regularization. That 30th January 2008 order, this particular person was not the petitioner. How can we expect the craft instructor to know all the orders, but authorities were knowing it? They did not place that particular order before the tribunal. But already there is an order.
What prevented you to go for a review of that order? 2008 order, madam, we are in 25. Notification came in 2015. You were not allowed in 2015 itself, which you challenged before the tribunal. Tribunal has said,
I challenge it in worship on
no, Mr.
these grounds.
Come with a better case, madam.
Another thing is, what about the Umadevi's decision, so far as the regularization is concerned, there is a time frame that has to be completed by within a given time limit.
You should have taken the ground here. She knows. You should have taken that ground 10 years continuing. Give me the benefit of the subsequent judgment.
These things were taken by the petitioner.
Very good. That was not considered. Now, 10th of
Challenging your lordship, all these things.
this, madam, 10th of December order 2008.
I will give me days time. I will call you one day. I will place certain decisions which matches with the facts of this case. And that's the lordship. I will not.
No, I'm aware.
So what is your subvision, sir?
My lord, this was never argued, and my lord, the CAT is also considered, my lord, in more Devi decision of the Supreme Court, my lord.
10th of December 2008. Now, Mr. Chakraborty, the 2015 notification, you have completed the selection process, or it has not been completed?
That, my lord, I'll have to check.
So, madam, you continue, be happy, you are 55. Whether they will, if they select at all, then they will disturb your service. But at this stage, Miss.
Just give me a day's time. Monday, lordship, positive. I will not go anywhere, lordship. I will be there. Monday, I will dispose of. Because one decision was there, your lordship.
নতুন লোক ঢুকছে কন্টিনিউ ওর অলরেডি বয়স হয়ে গেছে 55 2008 অর্ডার নোটিফিকেশন 15 রিট পিটিশন ফাইল করেছে 2017।
Please, your lordship, because today is the first day, your lordship. I was expecting that Union of India has not been served, so your lordship may not.
No, we shall give you time. We are wanting to know, madam. Though regularization is not possible apparently, still you have been granted the protection to continue with the post till a regular person comes. Harveer Singh, Supreme Court. So that order has neither been challenged by them nor by you. So that order was of 2008. Fresh notification came in 2015 and we are in 25. So all throughout from 8 to 25, you have got the benefit of that order. Now, if I don't know what is the stage of the selection process as to whether they have at all completed or not. If it is done, then the new incumbent will come. So if you can continue a few more years, regularization will be what? Question of regularization, you will get regular pensionary benefits and everything. But this part consideration will give you a lesser retirement benefits. They will, maybe there is a procedure of granting a lump sum gratuity. So instead, before we dismiss the matter, we are interacting with you to this extent. If you want to go into the merits of the matter, then we will consider. But if the selection process is not completed, how you are prejudiced, madam? Because it is a big hurdle to overcome that order. That order is binding upon us. Had it been a tribunal order, we would have certainly considered. No, it's not.
It's not High Court's order. Tribunal order.
Yes, tribunal order. This order was not assailed by you because your regularization was denied.
It was not assailed by me because I was not aware of the order of 30th January.
Okay, Mr. Chakraborty, let us know on the next date what is the status of the selection process.
Well,
And if we find that there is no, we will record that.
Yes,
and she will not be disturbed.
selection process of 2015.
2050. Most probably it is still going on because she has not been thrown
No,
out.
Your Lordship, 10 years have passed.
Hmm, 10 years. So it is better you keep quiet instead of getting a dismissal order from us. You know that.
Your Lordship, one judgment is there of the Honorable Supreme Court that I will place possibly, so far as I remember, about similarly situated persons, even if there is an order. But if the persons are similarly situated, same treatment has to be given. That, Your Lordship, I will.
We are not disputing that. That ought to have been your argument before the tribunal.
It was at this stage.
So that was not considered, order was passed. Neither you prefer review, nor you go to High Court. So how can this be reopened by us after 10, after 8, 10, 15 years, we can be upset that, madam.
Your Lordship, let me come back. I will just look into it. There is certain things, Your Lordship, which is to be.
Yes.
Your Lordship, that was the decision in the Supreme Court judgment. That's what I remember.
But that
You find out, you find out,
either.
you find out as to how that order can be reopened by us after 15 years.
Yes. Yes,
I don't think you will get any judgment.
I will look into
Look into it. Hard Miss Nagland, advocate appearing for, senior advocate appearing for the petitioner. না এরকম in course of evidence service as file be kept on record. In course of hearing, Miss Nagland, senior advocate appearing for the petitioner, prays for a short accommodation to avail necessary instruction. In view thereof, list the matter for further consideration. And yes, tell us when do we keep it? Monday we have many matters. It will be on 8th, Tuesday. And in the meantime, Mr. Chakraborty.
Yes, ma'am. I will accept.
Your Lordship. These are
Which papers?
your plain written statement, everything, Your Lordship. Just to go through, Your Lordship, in case of requirement. This is that case, Your Lordship, yesterday I was arguing.
Illiterate letter.
Illiterate.
When did the plaintiff expire?
Plaintiff expired. Just give me 2 minutes. Your Lordship. Just give me 2 minutes, Your Lordship.
সেই জন্য power button was not same. Overlapping the public works department. Yes, Mr.
Just give me some time, what's the date of death and.
No, let your junior find it out. That is must be during subsistence of the suit because husband got substituted.
Husband and son.
Son also got substituted.
Yes, K. Subramani and Kalini. Both were substituted.
Yes.
You know, see, my only point is that before the learned trial court, argument was advanced that there has not been any kind of proof with regard to the sale deed by the defendant. That argument was advanced. And illiteracy is proved. There is no doubt about illiteracy. Now, Your Lordship, my only, this is a point of law. When the entire thing comes before the court and the learned trial court says about 101, 102, burden of proof issue has been discussed by the learned trial court. It is not that that was not at all discussed. I can say, Your Lordship, if it is not discussed, we have not argued. It was discussed. The court discussed about burden of proof, onus of proof, everything discussed, trial court, but failed to observe 111. And how I can say, Your Lordship, because Your Lordship knows, many times we argue the law point, but the court does not consider it to be so important and ignores it. The thing comes into picture.
It is admitted, it was considered.
It was, and in the
Ultimate,
also.
no, madam, the ultimate finding was that initial burden is upon you. Initial burden is upon you, but when it is a case of reposing faith or fiduciary relationship, in that case, the validity has to be affirmed by the defendant. But the court in the facts and circumstances found that this burden does not shift.
No,
Why?
111 was never discussed by both.
No, it was discussed. Yes.
See that, Your Lordship.
I will show you the appellate side, the appellate court order.
Yes, Your Lordship, let it be seen.
No, he will just.
Just simply, Your Lordship, 111 is not applicable.
It is.
How it is not applicable? Is it not required, Your Lordship, to look into it when we are seeing the judgments of the Supreme Court as well as by this honorable court, stating that in a case of persons who are illiterate, this 111 has to be applied and looked into. It's a simple 3-line sentence. Page number 15, in the page 15. The plea of the learned lawyer is not tenable, that the respondent is required to discharge his onus. That's it. Why and how? No way discussed.
According to him, that you have failed to discharge initial onus. Maybe he has given.
Let me explain. Kindly see the judgment of the Honorable Supreme Court and this Honorable Court, Your Lordship, I have cited. The second judgment of this honorable court in second appeal, which has been disposed of exactly
No,
the
he
same
has
situation.
said that as because initial onus which was upon the plaintiff could not be discharged in this case by producing any of the attesting witnesses.
Why I should appear,
Why you have not produced your own
Husband.
husband?
that is what, Your Lordship, I am submitting, that husband, he is also an illiterate, what I will.
No, no, he's a,
Government servant.
you could have brought him at the witness box and then then established it. Madam, court proceeded on the basis, there is no dispute as regards the proposition of law which you are arguing. You are right, you are absolutely right. This is a proposition of law, whether there has been a shifting of onus in terms of 111, which as is required. That has been discussed, 111 was discussed. Court proceeded on the basis that the initial burden you ought to have proved.
I did it, Your Lordship, but not, Your Lordship, may I will explain. Initial burden I have to prove by way of producing the plaintiff, not by attesting witness, Your Lordship. Kindly visualize the situation.
No, there is a special cloak of protection. What is that? If the illiterate person has the scope to get independent advice from her relatives, then it would not have been. You cannot say that initial onus has been discharged by not producing. Only by producing.
Advice from, yes, Your Lordship.
From her.
Husband, illiterate, thumb impression.
No, husband not illiterate. That is a statement made by you, but it is found that he was a good staff in the
He
APW.
was a labor, he was used to put thumb impression. He was not knowing even to sign it.
What is the LTI of those persons? There is no LTI.
It is the same thing we are receiving.
So this was.
Yes, Your Lordship.
আরে LTI তো এমনি নেবে, এমনি আমরা তোরও LTI নেবে।
No, it has to be LTI by the pain of.
Yes, it is there.
In the pain of. There is no such
Your Lordship,
comment. LTI
kindly see just one second.
for identity.
এটা identity.
Your Lordship, we kindly come to
Hmm.
page number 133, the book, 133.
What is the name of the husband?
Kalimuttu.
Kalimuthu.
Yes, Kalimuttu. Yes. P. Kalimuttu. His name was P. Kalimuttu. Your Lordship, this is also a very peculiar thing, Your Lordship. Nowhere in the evidence, either the defendant, because the defendant, they have come to in the written statement or anywhere else, they have mentioned that husband was the witness of the same thing. Nowhere. What was my case, Your Lordship? May I, Your Lordship, just 1 second, I'll take 1 second.
No, what you are showing at page 133
Thumb impression.
of the plaintiff.
Witness. Down, number 1.
Hmm.
LTI of Kalimuttu. So that Kalimuttu was also an illiterate person.
Then why did you bring him in box? You could have proved it. You ought to have proved it in the box. He's your husband.
That is the point, Your Lordship. I have been agitating. Kindly, Your Lordship. Give me some time. I will. Because this particular, actually, Your Lordship, now also, this particular, the family, they all along agreed to sell 200 square meters. There is no doubt about it. They said that 200 square meters may be disposed of. He gave 50,000. Whatever the amount is there, afterward, whatever you are getting, you give it to me. Till even today, 200 square meters is not disputed. We are not intending that all 300 square meters sale deed should be cancelled. Complete 300 square meters should be given to us. We are not on that line at all. I am submitting, Your Lordship. It's 200 square meters. We agree. The lady agreed that it should be sold. Now, whether he has taken it on his own by executing the sale deed or whether he's selling it outside and not getting the sale consideration, immaterial. I am only concerned about the left out 100 square meters. That is the actual story, Your Lordship. Because I am on that particular land, my family is residing there. No, by filing an application under Order 2609, we wanted to prove that we are still residing there and we have been continuing to reside there. The appellate court rejected it. Anyway, Your Lordship, my only contention is that kindly visualize the situation, Your Lordship. what was our case? The plaintiff's case was that the defendant, who was the family friend, he came with typed bond papers, got the thumb impression of the plaintiff, Muniyamma, got the thumb impression of the husband in all the pages and went on. That is our case. We made. Defendant said everything denied. Nowhere it is been stated that husband of the plaintiff endorsed his thumb impression as a witness in the sale deed. Nowhere in the written statement. The case proceeded. Even in the cross-examination, that thumb impression, name is little different. He is P. Kalimuthu, this particular person is Kalimuthu. We don't know both are same or not. Nowhere it is there in the entire evidence that both the persons are same. Even in the cross-examination of the PW1, the defendant did not state that, yes, did your husband put this thumb impression in the sale deed? There was no such cross-examination. So, from the documents, it is only a presumption of the court that though both the Kalimuthus are same. At the same time, the appellate court is saying Kalimuthu was a government servant, working as a government servant, so he had the knowledge about the sale. If that be so, then that Kalimuthu who has put his thumb impression would be different one. Because a government servant having full knowledge of what is written in the sale deed will not put his thumb impression. He will sign. No fear from this. And now, Your Lordship, coming to the other aspect. Let us consider this aspect that there were two attesting witnesses. Independent two attesting witnesses, because from the documents, Your Lordship, I will show one by one every document. From the document, this is perverse. Perversity. The learned appellate court said,
Your only ground is 111. You satisfy us on that.
Your Lordship.
Your only ground you want us to admit is on 111. You satisfy.
Yes.
You satisfy that you have discharged your initial burden. There has been a concurrent finding of the courts that you have failed. And this you cannot agitate at this stage.
Yes.
Yes, ma'am.
First, Your Lordship, what I am required to do. That is to be seen. A plaintiff who is an illiterate person, what she is required to do to prove that she is not in active, means other party is an inactive confidence. What she has to show. This is to be looked into. She has to prove that she is an illiterate person or in a position where the other person is in active confidence.
She reposed faith on him.
She reposed faith on him.
Where is that evidence?
If she is deposed. When she deposed, there was no cross-examination to that. There was no cross-examination to that effect. That yes, there was no such relationship between you people, or there was you are not an illiterate person. No. Illiterate person, Your Lordship, just how I will prove? I have proved that I am an illiterate person. My only thing was there to prove that I am an illiterate person. Now, the next thing is that, yes, illiterate person also, the onus lies upon me to prove that I was not knowing the contents. Am I right, Your Lordship? Illiterate person cannot execute a deed, that is not the law. They can execute. I am an illiterate person, proved. The next thing is that I have to prove that I don't have any knowledge of all the contents of the document. Am I correct, Your Lordship? To that, I produced the sale deed. Sale deed was exhibited. There are 3 copies of different sale deeds. I'm not going into deep into the evidence part. Only one thing. Anywhere in the sale deed, it is written, read over and explained in the language of the plaintiff, anywhere. I am out, Your Lordship. These are the two things which I am required to prove. Once I prove that I am an illiterate person, and once I prove that the contents are not read over to me, burden shifts upon them. These are the only two things, Your Lordship. This was,
But still you will not produce your husband as the witness.
that's what Your Lordship, I am again submitting. That Kalimuttu is considered by the court as a husband. I never stated he is my husband. The person who has.
You have not denied that also, that he's not your husband.
There is no evidence there. How can you deny?
That is the record, madam. Shall the record shows your husband's name, attesting witness and husband's name.
It is not.
You show us that you have said that he is not my husband.
Your Lordship, I will say when there will be a version of the other side that he is
Oh
even.
my God, it is,
Say.
you will not prove here. That is the vital witness for proving the document.
Your Lordship, may I say, just a minute.
An attesting witness there, he's your husband. Now you are saying in the second appeal stage, no, he's not my husband.
So, Your Lordship, kindly come to the. That's why, Your Lordship, I'm don't get annoyed, Your Lordship, because I want to show.
No, it is not a question of annoyance. We have hardly, you are not being able to satisfactorily reply to this issue.
I'm replying.
Your reply is that it has not been read over and explained to me, and that person was in active confidence. These are your two grounds.
My two grounds. Now, Your Lordship, kindly come to the part, that particular part.
Kindly see the flip side of it.
Your Lordship,
He came, he gave the money. This 200 square meter which you're saying I'm admitting, to that effect, even if LD is then there will be no challenge. Now you are saying that no, you are making it 300. You have made it 300 illegally. That more shifts the burden upon you to establish through production of the attesting witness or any other witness.
Your Lordship, I never said that I agreed to sell 300 square meter to him.
Right? We are saying.
Power of attorney was decided to be executed in his favor. What is my case, Your Lordship?
Your case is power attorney was executed on an understanding because I had confidence upon him. He said, take 50,000. I took the 50,000. I was waiting for that matter to be sold out to a prospective purchaser so that if any additional is given, I will get.
Up to 80,000. Up to 80,000 will be given to him. About
That he will take.
Yes.
So at the time of power of attorney, why, madam, money is advanced to you? That is the issue of active confidence. Since I had confidence upon you,
Yes.
now the power of attorney when was executed, you are having an attesting witness. You will not say that my husband is there. I will call him to the box and he will establish the contents. This murders you.
Your Lordship,
This goes against you and subject to correction. What my learned friend thinks.
And another thing is that the sale permission has been obtained.
Sale permission has been obtained, Your Lordship. Sale permission is always obtained by filing an application before the Deputy Commissioner. That particular application which has been submitted, that has not been executed.
No, communicated to you. Permission communicated to you.
House.
Yes, to your house.
House is not covering the entire area of 300 square meters. It's the house. It is.
All right. Anything else you have to?
Let me. Your Lordship, kindly come to the judgment. Your Lordship, because. Your Lordship, kindly come to the first judgment of the Honorable Supreme Court.
You are taking us to the citation.
Citation, Your Lordship.
No, you satisfied. What do you want to show from the trial court order?
Your Lordship. Trial court order, Your Lordship. You can.
You will place that reasoning in respect of issue 9. that is 4, 5, 6 and 9 were taken together?
Yes. These four issues are vital issues for education of the instant suit.
That is internal page?
7.
Ah. Yes.
These four issues are vital issues for adjudication of the instant suit, which are taken up together as being interim, and for the sake of liberty and convenience of discussion. The alleged case of the plaintiff is that she happens to be the owner of the scheduled property measuring 300 square meters. And the defendant, who is having a good relation with the plaintiff, requested her that he will arrange the buyers of 200 square meters of suit land out of 300 square meters of suit land. The plaintiff accepted a set proposal in good faith. Taking that opportunity, and as the plaintiff is an illiterate lady, the defendant herein, by way of misrepresentation, has made the plaintiff to sign over the sale deed instead of the power of attorney which she agreed to sign in favor of the defendant. It's some impression, your lordship, sign over these deeds. The plaintiff further stated that she had no intention to sell her entire land, rather she intended to sell 200 square meters of land. She has stated further that except 50,000, which she has accepted from the defendant, she did not receive rupees 37,000 from the defendant. So according to the plaintiff, the sale deed is valid law and thus cannot be enforced lawfully. The defendant, on the contrary, has refuted the case of the plaintiff and has stated inter alia that the sale deed was executed and was registered in accordance with law, and the plaintiff had full knowledge about the same. It was further stated that the entire sales consideration amount of rupees 80,000 was duly paid by him to the plaintiff. So according to the defendant, the instant suit is liable to be dismissed. It was submitted by the learned advocate for the defendant, and the plaintiff has falsely asserted the sale deeds were registered falsely without the knowledge. The burden of proof lies upon the plaintiff to prove their case. The learned advocate for the plaintiff, on the contrary, raised serious objection against such consideration, stated inter alia. The defendant must prove that he has complied with every conditions of the registration of a valid deed. Even if it was so submitted, even if it was also submitted, the defendant must show that he has paid the entire consideration amount to the plaintiff. As this accused stands of consideration, it is essential to look into the definition of burden of proof as initiated in Evidence Act. Section 101, 102, and 103 of Evidence Act speaks about the burden of proof which deems as undue. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. On whom burden of proof lies? The burden of proof in a suit or proceeding lies on that person who would pay if no evidence at all were given on either side. Burden of proof as to a particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is so provided by any law. The proof of that fact shall lie on any particular person. In this regard, it is important to mention the observation of the Honorable Ethics Court in Anil Rashi versus Gulbar Singh. It has been held that the burden of proving the facts rests on the party who substantially asserts the affirmative issues and not the party who denies it. And the said principle may not be universal in its application, and there may be an exception too. The purpose of referring to the same is that if the plaintiff asserts that a defendant had acknowledged the signature, it is obligatory on his part to substantiate the same. But the question would be, what would be the consequences of a situation where the signatures are proven and there is an evasive reply in the written statement, and what should be considered as substantiating the assertion made by the plaintiff? In Krishna Mohan versus Pratima Mehti and others, it has been ruled thus: when fraud, misrepresentation, or undue influence is alleged by a party in suit, normally the burden is on him to prove such fraud, undue influence, or misrepresentation. In Sashi Kumar Banerjee, a constitution bench of this court, while dealing with the mode of proof of a bill under the Indian Succession Act, observed that where the aviator alleges undue influence, fraud, and coercion, the onus is on him to prove the same. In A. Raghavama and another versus A. Chenchamma and another AIR, while making a distinction between burden of proof and onus of proof, a three-judge bench opined thus: there is an essential distinction between burden of proof and onus of proof. Burden of proof lies upon the person who has to prove a fact, and it never shifts, but the onus of proof shifts. The burden of proof in the present case undoubtedly lies upon the plaintiff to establish the factor of adoption and the of partition. The said circumstances do not alter the incidence of the burden of proof. Such considerations, having regard to the circumstances of a particular case, may shift the onus of proof. Such a shifting of onus is continuous process in the evaluation of evidence.
Sorry.
Yes. I will continue, Your Worship, then I will place. It is therefore clear from the above discussion that in cases where a registered deed is challenged by the plaintiff on the ground that it has not been registered in accordance with law and that the same has been prepared by fraud and misrepresentation, the burden of proof lies upon that particular person who wants the court to believe that a said registered deed has been executed by misrepresentation and fraud and not upon the person in whose name the said deed was executed. In the instant case on hand, the plaintiff asserts the sale deed which has been executed and subsequently registered was by way of misrepresentation, and she, being illiterate lady, had no knowledge about the nature of the document, as she was told by the defendant that deed to be registered is a power of attorney rather than a sale deed. Therefore, the burden of proof lies upon the plaintiff to prove her case rather than the defendant to prove the deed was correctly executed and registered. Let me now illustratively analyze the facts and circumstances of the instant case in the light of the evidence adduced by the plaintiff in order to see whether the plaintiff has actually discharged her burden to prove her contention. It is a case of the plaintiff that she is an illiterate lady suffering from several mental disorders like schizophrenia, insomnia, hysteria, and had to undergo treatment in the lunacy home. In support of such contention, the plaintiff is found to have filed and exhibited a certificate of Dr. S. Kaga dated this, who has stated that the plaintiff has undergone treatment as she is suffering from schizophrenia. In my opinion, such certificate was issued way back in 1984, and no document has been placed by the plaintiff before this court showing that at the time of registration of the sale, the plaintiff was suffering from such disease of mental disorder. It is worth mentioning here that schizophrenia are of many types, and in order to succeed, the plaintiff should have proved that at the time when the sale deed was executed and registered, she was suffering from schizophrenia and had no parental capacity to understand the nature of the document. It is the case of the plaintiff that during period 1990-91, she intended to sell 200 square meters with an out of 300. As such, it can be very well inferred that the plaintiff was not suffering from schizophrenia and she had expressed her intention to sell 200 square meters of land out of 300 and thereafter accepted 50,000 cash from the defendant. The plaintiff has further taken plea that she is an illiterate lady. This contention was not opposed by the defendant in his written statement. Even I do not find any material on record which contradicts the contention of the plaintiff. As such, it can be very well said that the plaintiff no doubt is an illiterate lady as it is not in dispute. Now, Your Lordship, pausing for 1 minute. This proof that I am an illiterate lady proved by evidence. The next thing what I was required to prove is that the defendant was in active confidence. These are the two things as per 111. Now, Your Lordship, the story which I have narrated, the entire story, and thereafter, Your Lordship, the evidence, because I can't go into the evidence, those have not been discussed. But Your Lordship, as I have told, that active confidence, illiterate lady and active confidence. Active confidence will be removed if by way of document I am exhibiting. Illiterate lady, I have proved, court also accepted. Now, the second point is that illiterate lady, the sale deed contents are read over and explained to her, nothing remains. I am out. I have produced a document has been exhibited. Document shows that it is nowhere, not even in a single page, it is written, read over and explained to her in any of the language.
Where did you take that ground?
You should
Where is that? Yes.
Yeah.
Yes.
It is there in the
Question of read over and explained will arise consequential to your illiteracy.
yes, Your Lordship.
Right.
And that
And that is not the
confidence, Your Lordship, confidence, the confidence of a particular person. If it is written, read over and explained, he has discharged his burden because that illiteracy goes away. It has been explained to her, nothing remains. Now, he is in active confidence. Once I am proving that I am an illiterate lady, that is sufficient to prove that the other person is in active confidence. That is sufficient. Now, in order to curb that thing, that no, I was not in active confidence because the contents of the document has been read over to her, matter ends, I'm out. Is there any kind of statement or from the document also it appears?
where in your evidence you have said that it has not been read over and explained. Where in your plaint you have said.
Yes, yes.
We cannot go into the evidence, but your in second appeal stage, madam, we cannot reassess the evidence. Whatever is there, it is there.
Yes, Your Lordship, I am only saying, I am not arguing on the basis of.
Show us that you deposed in front of the. Please show us on record, on the evidence, show us that you uttered a single line in your plaint, or where in the evidence you have said that it is not read over and explained to me.
It is there, Your Lordship, just a minute.
It has to be dealt with in its totality. A particular clause cannot be put from the extracted on the records and highlighted at the second appeal stage. Your entire case has to be compositely considered.
Yes.
That is exactly what has been done. That is exactly what has been done.
Your Lordship, it has to be, Your Lordship, but what my suggestion is, Your Lordship, we kindly visualize the situation. Kindly visualize the situation. That a person, story goes in that manner. And now, Your Lordship, legally what is to be done by me? What can be done by and what has been done by? Legally, what is to be done? Legally, I have to show two things only. I am an illiterate person and the person was in active confidence. These are the only two.
Court has to go to the composite nature. You cannot say that don't consider anything else, only on this point you give me the decree. You cannot, madam.
Can, Your Lordship,
That is exactly what has been done. You have failed to place the attesting witness.
they
You have got the permit step to you. You are disputing service of it. And furthermore, for confirming your possession, because there was no evidence as regards your continuous possession. So you brought in an application under order 26. That's true at the fag end of the appeal.
No, that, Your Lordship, I'm leaving that particular thing. I'm not arguing on that point. I will
Sorry,
just
madam.
give me some time, some more time, Your Lordship, some more time. I will place the judgment and Your Lordship can decide it. I will not.
দেখতে চাচ্ছি স্যার। না না শোনো ওর কমপ্লিট করে ফেলেছে। ফরওয়ার্ড ছিল তুই রেডি করে দিস। Yes.
Your Lordship, so far as the burden of proof is concerned, Your Lordship, where once the owner shifts, Your Lordship, kindly consider
Yeah.
every aspect.
Yes, your argument we have
Your
understood.
Lordship, I have not examined that testing. I have not examined that testing with us. Let us.
No, your argument we understand. Your argument,
Lordship, defendant can ignore everything. He will not examine a testing witness. There are two testing witnesses. I can understand. If he says one is husband, another one was there. There is nothing on record to show that the other person has died or he has not coming. No attempt was taken to bring that witness. Your Lordship, once the owner shifts, now we have to see what defendant has done to prove that the sale deed has been executed after reading.
we are in the second appeal stage,
You know,
madam.
that's what Your Lordship,
We cannot go through the evidence now.
I'm not saying.
All right, show us which one, which judgment you are relying
Yes,
upon.
Your Lordship, first of all, the paragraph, Your Lordship, paragraph 12 of my plaint. Paragraph 12.
Paragraph 12 of your plaint.
Yes.
Yes.
Sometime in the middle of April 1991, the defendant came to the plaintiff and asked her husband to put their thumb impression on some type envelopes, which he described as deed of general power of attorney. As the plaintiff and her husband were having full faith and confidence in the defendant, they in good faith put their respective thumb impression on various places on those bond papers, which were typed once. Apart from those bond papers, thumb impressions of the plaintiff were obtained on some other papers also, description whereof were not known to the plaintiff or her husband. Specific averment is there, Your Lordship. Now, specifically mentioned. And then, not a fact is there. In the cross-examination, a suggestion is put. It is not a fact that the contents of the same was read over and explained to me and found to be correct. That's why I put my LTI. Not a fact is also there. Then, Your Lordship, under such circumstances, are the court not required to look into the sale deed? Whether read over and explained to me is written or not.
Yes,
Once these two things are shown to the court, Your Lordship, the onus shifts upon the defendant. Now he has to bring the attesting witness to prove that the sale deed has not been, the sale deed has been executed after knowing the contents of the documents, and all these things are false.
yes.
So, Your Lordship, this is the evidence. This is thank you, Your Lordship. May kindly come to the decision of the Honorable Supreme Court, Your Lordship, one by one, I will be facing it. Your Lordship.
That just one.
Yes.
That suggestion in which page?
Yes. Page number, just 44. And in the cross itself, it has come. I never applied to the Deputy Commissioner for Sale Commission of the city. In the cross, it has come. Usually, perversity is always one of the consideration which in where the second appeal, Your Lordship, is admitted.
Yes,
Yes. This one. Fine, I'm placing the judgment.
Yes.
Your Lordship, the first one is Krishna Mohan Kul alias Nani Charan Kulinj. Paragraph 12. As has been pointed out by the High Court, the first appellate court totally ignored the relevant materials and recorded a completely erroneous
Paragraph.
paragraph 12.
Yeah.
As has been pointed out by the High Court, the first appellate court totally ignored the relevant materials and recorded a completely erroneous finding that there was no material regarding age of the executant when the document in question itself indicated the age. The court was dealing with a case where an old illiterate person was stated to be the executant and no witness was examined to prove the execution of the deed or putting of the thumb impression. It has been rightly noticed by the High Court that the courts below have wrongly placed onus to prove the execution of the deed by Dasvichar and Pool on the plaintiffs. They were challenged by the plaintiffs to the validity of the deed. The onus to prove the validity of the deed of settlement was already given. Number one, when the fraud misrepresentation or undue is alleged by a party in the suit, normally the burden of proof is on him to prove such fraud, undue influence, or misrepresentation. But when a person is in a fiduciary relationship with another, and the latter is in a position of active confidence, the burden of proving the absence of fraud, misrepresentation, or undue influence is upon the person in the dominating position. He has to prove that there was a fair play in the transaction and that the apparent is the real. In other words, that the transaction is genuine and bona fide. In such a case, the burden of proving the good faith of the transaction is thrown upon the dominant party. That is to say, the party who is in a position of active confidence. A person standing in a fiduciary relation to another has a duty to protect the interest given to his gain, and the court watches with jealousy all transactions between such persons so that the protector may not use his influence or the confidence to his advantage. When the party complaining shows such relation, the law presumes everything against the transaction, and the onus is cast upon the person holding the position of confidence or trust to show that a transaction is perfectly fair and reasonable, that no advantage has been taken of his position. The principle has been ingrained in section 111 of Indian Evidence Act 1872. I'm just pausing for one moment, Your Worship. Both the courts did anywhere discuss this. Now I'm continuing. The rule here laid down is in accordance with the principle long acknowledged and administered in courts of equity in England and America. This principle is that he who bargains in a matter of advantage with a person who places a confidence in him is bound to show that a proper and reasonable use has been made of that confidence. The transaction is not necessary void ipso facto, nor is it necessary to those who impeach it to establish that there has been fraud or imposition, but the burden of establishing its perfect fairness, adequacy, and equity is cast upon the person in whom the confidence has been reposed. The rule applies equally to all persons standing in confidential relations with each other. Agent, trustees, executor, administrators, auctioneers, and others have been held to fall within the rule. The section requires that a party on whom the burden of proof is laid should have been in a position of active confidence. Where fraud is alleged, the rule has been clearly established in England that in case of a stranger, equity will not set aside a voluntary deed or donation. However, improvident it may be, if it be free from imputation of fraud, surprise, undue influence, and spontaneously executed or made by the donor with his eyes open. When an active confidential or fiduciary relation exists between the parties, there the burden of proof is on the donee or those claiming through him. It has further been laid down where a person gains a great advantage over another by a voluntary instrument. The burden of proof is thrown upon the person receiving the benefit, and he is under the necessity of showing that a transaction is fair and honest. Now, yes, paragraph 17. The logic is equally applicable to an old, illiterate, or ailing person who is unable to comprehend the nature of the document or the contents thereof. It should be established that there was not mere physical act of execution involved, but the mental act. Observation of this court, though in the context of Pardanishi, are logically applicable to both voice of the whole invalid, infirm, and illiterate person. Now, your lordship, this is one judgment. And just to show the perversity, your lordship, I just wanted to show one thing.
Yes,
The next one, your lordship, by this honorable court, your lordship.
yes.
Second appeal is always heard by the single bench, your lordship, so I have to place that. As it was admitted, your lordship, and thereafter it has been adjudicated. I may be permitted to place it, your lordship, because the facts are exactly the same. The instant appeal has been preferred, your lordship, not that one. Devashish Das.
Yes.
I will be placing only two judgments, your lordship. This is the last.
Yes.
This instant appeal has been preferred by the appellant plaintiff being agreed by and be satisfied with the judgment and decree passed by the learned assistant district judge. Fifth court one on this entitled appeal being titled appeal number this hearing number this of this. The aforementioned first appeal being titled appeal number this was preferred by the instant appellant being agreed by the judgment dated this passed by the learned civil judge unit division. Second court one entitled suit number this. The appellant hearing was the plaintiff before the trial court and the appellant before the first appellate court while the respondents hearing were the defendants before the trial court and the respondent before the first appellate. Facts of the instant list as has been depicted by the appellant plaintiff in the claims. A registered instrument being an alleged sale deed is said to have been executed by the appellant plaintiff in favor of the respondent number one, that is the elder daughter of the appellant. It has also been stated that the appellant executed the impeding deed on ground of being the power of attorney. Instead of being a power of attorney, the alleged instrument has been registered as a sale deed, which the appellant is claiming to have been made falsely by the respondent number two, with the help of the respondent number two, who is the elder son-in-law of the appellant. It has been stated by the appellant that the appellant had full faith and confidence reposed upon the respondent defendants, and being an illiterate person had signed on the alleged instrument, as such fraud has been committed upon him. As such, the appellant plaintiff has sought for a degree, rejecting the instrument. When facts before the learned, I am skipping this. The same has been done. Facts before the first appellate court. Facts before the first appellate court being agreed but dissatisfied with the judgment passed by the learned civil judge, the appellant plaintiff preferred anything. The learned first appellate court considered the submissions of the learned counsel representing the appellant plaintiff as well as the respondent defendants and had framed the points of consideration as follows. Then we also this one. These are the these two
Description labels were not known to the plaintiff. Description label.
Yes.
যেকোনো জিনিস আমি যদি আমি যদি পড়ে আমি জানতে পারি ফার্স্ট থিং তো আমার হচ্ছে যে আমি জানতে নিয়ে আসবো
When
Yes.
evidence was going on, Your Lordship, she was 80 years old. Your Lordship, I'm just placing it. Next 2 pages, Your Lordship, these are the argument of the counsel. So I've just kindly come to the, after 2 pages, 8, clause 8, the learned trial court has been pleased. 8,
Eight.
paragraph 8, just 2 pages after that. Page 5, inner page 5.
Yes.
The learned trial court has been pleased to dismiss the suit holding that in the instant case the plaintiff has not been able to successfully rebut the presumption either by oral or documentary evidence, except alleging that a registered deed of sale was falsely manufactured by the defendants taking advantage of his illiteracy. The first appellate court has been pleased to dismiss the first appeal and to affirm the judgment of the trial court holding that it is settled principle of law that who claims to take benefit of a particular disability must prove that he suffers from such disability, and as held, the trial court has rightly held that in transaction with an illiterate person, the burden of proof is on the person who relies on any document executed by the illiterate person to show that such illiterate person not only executed the documents by putting his thumb impression, but the contents of the said document was explained to the illiterate person and he understood it. An appellant has not been able to establish his claim, and he has signed on the impugned deed under the misconception of the fact that it was the power of attorney. The learned trial court and the first appellate court have placed the onus of proof upon the appellant plaintiff and have come to a conclusion that appellant plaintiff has failed to prove his case that he is an illiterate person. The general presumption of a registered deed is that deed is validly executed, and one who has challenged the registered deed, the onus of proof lies upon him to prove that the deeds have not been validly executed according to the provisions of 101 of the Evidence Act. But when a fiduciary relationship exists between the parties to the deed, and the question of reliance has arisen, then the onus of proof shifts upon the person who is claiming the deed to have been validly executed according to the provision of section 111 of the Evidence Act. Then, Your Lordship, again, the repetitions are there, the fiduciary relationship and all. Then So, Your Lordship, inner page 14, paragraph 21. There also, Your Lordship, there 2 witnesses were there. One was the son-in-law. One was the son-in-law. The impugned deed has 2 signatories and witness, one out of whom one is the elder son-in-law, who is an interested party, while the other one, who is not an interested party and being a neutral, has not come before the court and tendered himself to adduce evidence. Because even if we assume about Kalimuttu, other was there. Why that other person was not produced by the defendant? What was the reason? Point is that, Your Lordship, both the courts did not consider it, did not even discuss how 111 is not applicable in my case.
What is the process of getting sale permission from this tehsil that I want to know? I want to know the procedure. So who will file the intending purchaser to file an application for sale, or the owner of the land will file for sale permission?
Owner of it.
So you have filed that,
That application is not exhibited anywhere. That is why, Your Lordship, I have stated,
there is some
may I, may I?
evidence is there that the sale permission was obtained or
Sale
something.
permission was obtained because he has obtained my signature on various papers. That is my case in the plaint itself. That in many papers signatures were obtained and the description of those documents were not explained to me. Your Lordship, I am not going deep into it because Your Lordship will not hear me to that extent. But one thing also should be looked into because that is a judgment of the Honorable Supreme Court, various courts. Where is the mode of payment of 80,000? 80,000 patient. Your Lordship, this thing ought to have been, my only thing is that whether both the courts discuss these things. This was all along my argument. And special thing, Your Lordship, and main important thing, Your Lordship, and main important thing, Your Lordship, that 50,000.
Are you hearing our discussion?
No, no, Your Lordship, I'm telling you 50,000.
From that step.
No, no, I'm not able to hear Your Lordship. I'm telling about that 50,000.
Yes, continue.
50,000 rupees, which I have stated, Your Lordship, in my claim. It has
2000 in the year 1995 or 1991.
Your Lordship, denied by the defendant, has not given.
2000 means today is 50 lakhs.
Oh,
Maybe, no. Maybe. I can't say that. No, 50,000 was given. I am saying that he has given 50,000. He is denying it. I have not given any amount. Straight denial. And the first appellate court says that I have received. Defendant is denying. First appellate court is saying I have received 50,000. My humble submission, Your Lordship, this is at the admission stage. And I'm praying, Your Lordship, that it may be admitted so that, Your Lordship, lengthy hearing can take place and the things can come out, Your Lordship, after hearing both the parties.
yes. Anything else?
Your Lordship, I'm just submitting, Your Lordship, that onus lies upon the defendant, Your Lordship, that onus has not been discharged by adducing attesting witnesses, Your Lordship. The judgment is there of the Supreme Court as well as by this honorable court, Your Lordship. Kindly consider that judgments, and I pray that the second appeal be admitted, Your Lordship.
The appeal shall be heard. The appeal will be heard on the grounds taken on the
Why not this matter? This matter, my lord, there was a direction for paper books, my lord. I'm handing over the paper book, my lord. I've served the other side. My lord, it can be fixed for arguments, my lord.
What is the issue?
My lord, I've just now, well, the matter is coming on a remand from Supreme Court, my lord.
Pardon?
They have invoked 311 2B
Acha?
to dismiss me, to dismiss me from service without having any disciplinary proceeding.
Charge?
Charge, I have been involved in a criminal case with regard to paper leakage. Immediately after my arrest, I have been dismissed from service. Then I succeeded on 3 occasions before the tribunal. They challenged it before this court upheld the order. Ultimately, they went to Supreme Court. Supreme Court on in this High Court order, there was one wrong recording. On the said score, my lord, it was remanded back to this.
You were not ready, Mr. Chakraborty?
No, my lord, just now, my lord, I've just now received the paper book, my lord. Kindly keep it tomorrow or when?
Tomorrow, we'll not find.
By Monday, my lord. Whenever, my lord, whenever. We just now received,
You are the appellant, you are the petitioners.
just now received the paper.
You have got the paper
Yes. So,
given to him.
yes, given.
Just now you have got the paper. Pursuant to the earlier direction of this court. Yes. Item?
This matter, my lord, there was a direction, my lord. Yes, we have just filed 1 day's time, my lord. It has been vetted, my lord. We filed, my lord, on Monday. Monday file. It is in vetting, my lord, the affidavit. We'll file. My lord must see the last order. There was a direction upon us to file an affidavit.
The instruction has come to you.
Yes, my lord, I have received the affidavit, my lord, but I have let it come on record, my lord. We have prepared the affidavit, my lord. It's gone for-
Prepared it. Then give her a copy so that we can.
It has gone for vetting, my lord. Only let it be approved, my lord. Monday we will file.
You can give me an advance copy.
No, it has gone for vetting, my lord. It's in the department. I cannot-
Monday I filed it. Sunday is an advance copy.
Actually, I'll-
When can you file it?
Monday, my lord. We'll file it on Monday.
So Monday you file and give a copy. to
Yes,
her.
yes. Yes. Because my lord, it's in Diglipur, my lord. That's distance from.
The 8th.
वो ठीक है।
Yes. Eight. Do we record that you can file it? Eh?
Yes, my lord, we'll file it on Monday.
Right.
Mr. Chakuti.
Lordship, there I am praying for extension of time to file paper. And doing all matters usually, I do not prepare it, Your Lordship. I require a week's time, Your Lordship. Praying for next service, Your Lordship. This one.
There was any direction for filing of paper books? There was no direction for paper books.
Actually, it's very voluminous. Also.
It was recorded by an order of 29 July that you have only submitted that all the papers are annexed.
Paper book, it's under process, Your Lordship. We have already sent it for.
Miss Nagland Red Book, senior Red Book, it appearing for the वो कर देना ना जो senior Red Book it है please appearing for the petitioner prays for leave to file.
There is not here.
What happened?
Counsel for the petitioner is not there. I am appealing for the private person.
Opposition and reply filed.
Actually, it's not required WPCT, my lord, but there is a direction, my lord. I've noticed that. Because the
Yes.
private respondent sought time, my lord. They don't want to.
What is the matter about?
The matter is, my lord, this is concerning disability reservation. Now, my lord, the contention of the unsuccessful petitioner who was not appointed to the post
Hmm.
is that the private respondent was given the benefit, although the private respondent is not blind because the private respondent drives vehicle, etc. Now, the
Oh my God.
CAT has held that the private respondent suffers from 40% disability, which is the requirement. And the private respondent has produced a certificate from a hospital, recognized hospital, which certifies that the private respondent is suffers from 40% disability.
This is appointment to which post?
The appointment is to the post of
Postgraduate teacher.
postgraduate teacher.
Post, you are working now
Yes.
and you
One
are
line is artificial eye.
and
Yes. The operation, it was removed in the year 2008. Thereafter, this was.
it appears you had been the doctor.
No, my lord. 2008, the operation was carried. Surgery.
No, it's a post regarding issuance of license.
No.
Regarding driving
No. It's a post of
Teacher.
postgraduate teacher.
postgraduate teacher. Oh. Who is the petitioner's advocate?
Mr. Sabir.
So, Sabir is a.
You have not used any opposition, not required, you are saying.
It's order has come now. I cannot say, my lord. I cannot say that. But it is technically not required because WPCT, my lord. And will be the same as was taken before the tribunal.
Before the tribunal, I was not served. I didn't appear.
Yes, that is why my lord time was given because the private respondent was not appearing before the tribunal. So they need to
Our
place
contention
their.
was that it was never served to him. So the High Court directed to serve. Thereafter, service was.
So how long will you take to file the
I can file
opposition?
by Monday, my lord. No issue.
File it and start, it will be on Tuesday.
Fine.
Yes, next. Tuesday. রেখে দাও। File it and serve and come back on Tuesday. Allow us to complete matters, sir. What? Again,
And my lord, one is appeared.
none appears.
None appears on 14th November. I find my lord, no one appeared. I don't know after that. What is appearing? Somebody from Gujarat, my lord, Mr. Otindra
Out of list করে
Mishra was
এ
appearing.
পড়ে থাকে যতক্ষণ না ইয়ে করে। হ্যাঁ, মিস্টার।
On 24th September 24, Mr. Otindra Mishra had appeared for the petition. After
Is
this,
there practicing counsel here?
no, Kolkata from Kolkata.
Then who is the advocate on record?
He's only advocate. Can be dismissed for non-prosecution, my lord. He can come, he'll file a restoration if he's interested.
No, he's, the earlier direction was let it go out of the list. The
But it is-
department has sent it because it's a pending matter.
Yes, my lord.
You don't, what is the matter about? Must be service related.
Service related.
So he must be your employee. You give a notice upon him.
My lord will see the order of 7th February 2024.
Ordered
This is
impugns
no, this is
28.
actually a different matter.
Uh-huh.
No, my lord, the matter is.
To enhance the
whoever was dismissed,
maximum
my lord.
extent of the ATM to
Relaxation, issue of age relaxation.
Yes, my lord. Prayer for age relaxation was rejected.
কোথায়? Age relaxation.
Kindly see page 205, 206.
So you take instruction and come and tell me whether it is still alive or not, post filled up or what, pertaining to which recruitment process. Please check it up and tell us to us. Then if nobody ever, who appeared for the Bhushan, Mr. Bhushan.
Bhushan appeared in the cat.
So Bhushan, he is in principal way,
Yes,
a friend of yours. Give him a call and tell that matters are lying, you are going to dismiss it.
You have, we'll inform him, madam.
If you can do so at least.
We will
Really,
send
it is, huh?
We will send a mail.
Email ID.
We'll send a mail. We'll serve him notice.
Ask them to appear virtually. Possible.
Actually, my lord, this has become infractuous.
Infractuous. That
They
is
could
what-
not- We could not, the petitioners could not participate in the recruitment process because they were overaged. And they filed this original application saying that they should be allowed to uh, participate by enhancing the age limit. But this is of, my lord,
No one appears on behalf of the petitioner. Though Mr. Chakravarti, the senior counsel, senior advocate appearing for.
send it, my lord, this paper book has been exhausted. Item 8 and 9, my lord. Both have filed an appeal against the order, my lord. Just two.
Allow us to.
No, it can be disposed of. My lord. Just a small point is involved. Within 2 days, my lord, I will file the paper book because the report, subsequently after the writ petition, my lord, a report has been submitted. Based on the report, the court has passed the impugned order, my lord. The only question is,
Order was passed.
based on the report we have submitted, there are the relief which is claimed by the petitioner was complied with, my lord. Because, but subsequently, the honorable court given 40% of the period which he has not rendered his service. So agreed by that 40%, we prefer an appeal. On the principle,
Yeah.
no payment.
Let us. Let us see the order. What is this scan application? Where is the order impugned? Order impugned which page?
My lord, there are 2-page order, my lord.
Uh-huh.
Only 2 pages order, my lord.
Where is that order?
But in the can application, it's
We
page.
got it. Have you got any money? You're the petitioner.
Yes.
They got it.
You have not got any money.
Back pages, my lord. No.
No, you have said that during which period he was not working.
No,
It was not uploaded. Which was the period?
the fact is that he has been rendered to as a DRM. When
DRM is a
related Mazdoor.
daily dated Mazdoor. Very good.
Because the issue was scrubbed up, it was went to an order passed before the order of Supreme Court. The administration prepared a database. Say that the other persons, nobody should be incorporated in the list, there should not be any malpractice. So they made a database. While preparing the database, it was based on numbers. So the particular petitioner's name was not incorporated in the database. So he has rendered a period for service. That period he has not paid the salary as the extension was not granted by the competent authority. Agreed by that, he preferred an application before the labor court, saying that the period which I have rendered, for that period I have entitled for the salary. And subsequently, he has filed a writ petition before the honorable court, saying that he is entitled for arrears of 1/30th pay as well as the salary for the period which he has rendered. And subsequently, on the basis of the order passed by this honorable court, we have released the salary for the period he has rendered and the arrears for the 1/30th arrears up to date. But while considering this aspect, the honorable court has passed an order
Saying that for the period his name was not there.
work for that period 40% has to be given.
No. Once the name of the petitioner is uploaded,
Yes, Madam.
it is expected that all payment due to the for the period that the petitioner was not allocated fair work due to the fact that his name was not registered in the West.
Total of
Which is that period?
That period is from October 2023
October 2023 to
December, I think, my lord. December 2024. That date, my 11th and 10th. Yeah.
so apart for this period he was asked to pay 40%. This you have not received.
I challenge it by filing a.
You challenge
Yes, this part.
Your
There are two appeals, Madam. I
Oh,
filed
yes,
for the
yes.
40%. They say that it should be 100%.
Because there is an admission on their part. My lord, may kindly visualize the situation. It is not a case where a person has been terminated for whatever reason. Here it's a case because the authorities were at fault whereby they did not upload my name, as a consequence of which is the only source of livelihood. I have been deprived to get my salary for all those period and I was running pillar to post, my lord. Only after the interference of this court, my name was uploaded. So this period I was not at fault and there is an admission on their part to that extent that it is due to our fault this was done.
very good. Then that brings out to the issue of 40% payment.
Yes,
The court has directed for that period you will get 40%.
I am seeking 100% because it is not a case where back wages will come into play. There was no, my lord.
You have not worked, sir.
No, my lord, not working and not allowed to work are two different things, my lord. They accept it, my lord. My lord, I have seen my lord's one judgment, latest judgment also, where my lord has not given back wages. This is not that case, my lord. My lord, I kindly appreciate because of the fault on the part of the authorities, and there is an admission to that extent, my lord. This is an exception to the general rule, my lord.
The court has exercised discretion.
My lord,
The court has given you the benefit. See, back wages is not a matter of,
my lord, I am not.
it's not a matter of right.
The law of back wages will not come into play so far as this case is concerned because there is an admission. This is not a case of illegal termination or termination, which is not saying that it is an illegal.
Where have you stated that during that period you have not been engaged anywhere else?
I am right.
That has not been stated.
Up to April, I was sitting all alone in the place of work, but they did not allocate it anyone.
Not there.
That is the pleading in the writ petition.
No.
There is a
Not they kindly come to the prior portion, Madam, once with the writ petition, Madam. The writ petition, the prior portion.
Release the monthly salary.
I have 20 of the writ petition. I have
We have never.
From October 20. Yes.
Not that period is the period which you have released the monthly salary on petitioner from the month of October 2023 onwards from discharge the duties and husband as daily rated employee. Not the period which he has rendered that period he has claimed.
Are sir, you are the state. You are the supreme.
Yes.
Not be kindly. Visualization.
Delegated Mazdoor, you are going to, the way you are saying authority administration will go to Supreme Court to contest.
We model it for him.
No, I
These
understand.
are
Not for
the
the
bureaucratic measures, Mr. Kumar. We are enjoying, we have been conferred the jurisdiction to exercise our equity jurisdiction.
should right, my lord.
With whom are you fighting, sir? A DRM. And you are the state lieutenant governor, principal secretary.
Lord, I understand the Lord, I understand the situation, but this is the principle.
That is why you are an officer. That is why you are an officer. It is upon you to convince these people. That much of ego. Then what is it, sir? You could have called the DRM, he would have shivered to appear before you. You could have called him, I am giving this, accept it. And show you. Well,
Definitely.
sir, kindly, our societal state, I am not saying that I am passing order in his favor. But see the chasm, see the difference. A principal secretary of a department and a DRM. What is the issue? Maybe the issue is of how much it will come. Say it is 20,000. The question of his livelihood. The thing is, we exercise our balance. That no, all right, he has not worked. I don't understand, sir. In starting from 1960 or Madras Port Trust case, you kindly see what is the duty of the administration.
Right.
You have to act fairly and in a reasonable manner.
Fair and reasonable.
Suppose nobody kindly see the. It is not that I am on, or I will give the petitioner the review. But the Supreme Court has said it has been the consistent decisions of the Supreme Court that when you are dealing with the lower rungs of the society, when you are dealing with the lower rungs of the society,
In one case, my lord, in
Not so far as not these.
sometimes it becomes an ego battle. No, I will not give. Let us see.
No, but that is not the issue. Not because he has been paid with the arrears as well as the payment. Not around 8 to 9 lakh rupees has been paid.
We are a senator and the principal. These are massive.
No, I am only on that. Only
The divisional, regional manager or something like that. That is a delegated Mazdoor.
not I understand. But the only principle is that no work, no pay. That is the only principle I approach in terms of this impugn order. Lord. If my lord will see.
Have you gone through the latest judgment of Justice, our ex-Chief Justice, Justice Chandrachud's judgment?
I will just.
That is in fact strictly not applicable
this-
here. That was in case of termination.
Yes, yes.
Back process is not a matter of right. We are not saying so. It is not a matter of right. Still, you can convince your client. They ought to have withdrawn this appeal or how much? 40% of that. All right, take this much. Finished. We will record this admission and finish it off.
that could have been done.
Offer some money. How long a litigation goes on, sir? When will we keep it? Any paper book or anything is there? We will decide.
Election was
Nothing
there.
is required, my lord. My lord has.
But I just filed a compilation already made as
My lord has asked me whether you have said that you have not worked for that period. In my writ petition, I have categorically stated at para 20.
So there are two petitions. Who was to file the paper book?
I was to file the payment.
Have you processed it?
I processed it, but just 2 days time, that is Tuesday or Wednesday, the matter, and I saw the advance copy to the other side, it can be displayed. Just
So let it be in the list.
Yes,
Let
yes.
it be in the list. If he, once you file the paper book, give it to him so that
Yes,
he
yes, yes.
not to take.
Monday, bro.
Monday.
On Tuesday, Monday.
আচ্ছা টিউসডে মনে হচ্ছে এটা যে টিউসডে ডেট দিয়ে রেখে দিও লিস্টে
Okay.
মনে হচ্ছে যে গ্রুপে টিউসডে ওয়েডনেসডে করেছে গ্রুপে লিস্টটা এমনি ব্র্যাকেটে দিয়ে
Okay.
Sir, can I submit? Sir, actually, I have received the reply. In their reply, they have accepted that the bus which met with an accident is almost more than 15-year-old. They have accepted in their reply in para number 11, and they also accepted in para number 7 that the failure was due to brake failure.
Reply.
Opposition.
Opposition, sir.
He is calling the opposition reply, my lord. We have filed opposition. He
Where is
wants
the
to
document?
file a reply.
Where is the
We
document?
have filed it, my lord. That's it.
মনোজ অপোজিশন কোথায়? ও এখানে না, এটা এভিডেন্ট সার্ভিস, এটা সাপ্লিমেন্টারি।
There is a small error, but I
Will
will
accept
rectify
yes.
Yes, sir.
Here there are some
Mistakes.
হ্যাঁ,
We have to correct those, my lord. But give us liberty, my lord.
Sir, not to, sir, one minute. Sir, what they are doing is, sir, they wrote that bus is more than 15-year-old, but they have, yes, sir.
when you will come before this court,
Sir, I will be,
will you be appearing before us in person?
yes, sir, I'll be appearing in person.
You are in the virtual mode, are you coming over?
No, sir, I'll be appearing in virtual mode because I'm in Delhi now, sir. I can't travel to Port Blair for physical hearing, sir.
See, so the evidence has not been placed before us. There are some mistakes which is still in the department. So we let the evidence, do you want to use any reply to that?
Yes, sir, I'll use the reply, but what I want is that as per the opposition they have submitted, I want a,
Not in before us, it is
oh,
us.
okay.
Here, we will take it up on Monday. You make up your mind whether you will use a reply or not.
Sure.
If you want to use any reply, are you making, do you want to use a reply to that?
Yes, sir, I'll submit reply to it, sir. I'll submit.
If I file a reply, then it will go to the next base, next
No,
subject.
sir, I'll submit the reply by tomorrow. I'll submit the reply by tomorrow. I have no issue.
Very good. You supply, file the reply. Give a copy to your friends. Give copies to your friends. How will you give?
Sir, by mail, through mail, I'll send.
Then how you will file the evidence in reply?
Sir, the last time the High Court judge allowed me to submit online, sir, to register directly to online.
এই এখানে হ্যাঁ ঠিক আছে, এখানে তো অনলাইন এসে যাবে তো।
Registry mail ID is there with me, sir. I can send it to registry directly.
Email very good. You send it by email.
Thank you, sir. Thank you. I'll send by Saturday. Thank you.
You send copies of them by email to the respective advocates.
Thank you, sir. Thank you, sir.
Email.
Yes, I'll send, sir. I'll send to everyone, sir.
All right, then you are keeping it on Tuesday. You file your evidence in the meantime and give the copies.
Thank you, sir. Thank you, sir. Thank you, sir.
এটাকে টিউসডে ডেট রেখে দিও।
Sir, if any interim order, then I'll be very much thankful, sir, because at least an order is required.
On Tuesday?
Yes, sir, but sir, the matter is I have filed, the accident happened in November last year. Till then, they had,
Procedure which has to be maintained. No interim order is passed in your favor on early allocation.
okay, sir.
Action was that use on opposition we will consider. So
Thank
if
you, sir.
the pleadings are complete, we will finally dispose of the matter if we can on Tuesday.
Thank you, sir. Thank you, sir. Thankful to you, sir.
Yes, we are coming back after half an hour. Okay, half an hour to
Normally these matters were listed, it's due to appear in the month of June only.
No, it is not so, your lordship, because the by 5th of April, they were supposed to file their affidavit in opposition. But they have not chosen to file it, that's why I have made a mention in file.
Direction to file opposition, they have not used it as a petitioner. Last order may kindly be seen, order dated 26 February 2025.
It's a pre-entry order, your lordship.
They have to means, madam has also to file the opposition.
So I have already used. They have found it for the revenue authority.
We have?
Brings extension time for filing my application. I have used my affidavit. She has,
Have you given a copy?
yes, I have given.
Suppose private response, I got it. Suppose party of the main part of the lordship. So let us come, lordship, once they use their opposition. What I have a right.
Pre-entry order, that is why I made a mention.
Pardon?
Pre-entry order to file their affidavit.
What is the matter about?
The authority.
You are enjoying inching or that?
Nothing.
Then you file your affidavit, give a copy, madam. You have given.
Already given in the report.
Archie,
Authority is seeking explanation.
Miss Ashun, Miss Zinula.
Section.
Preliminary objection. What?
The writ petition, my lord, has been filed by a person who is not competent. Because, my lord, admittedly, my lord, the term of the management committee of the bank has come to an end on 28th of February 2025. This writ petition, my lord, is filed with the affidavit of a person claiming to be a director. And that person's term has admittedly come to an end. So the management committee's term has admittedly come to an end on 28th of February 2025. But, my lord, the affidavit is affirmed by a person who is claiming to be, my lord, a director. So, my lord, as
He was a director of that managing committee,
before, but
which has
come to an
expired.
end, which has come to an end.
It has come to an end when?
28th of February 2025.
28th of February 25.
End of February 2025. And the writ petition, my lord, was filed on 1st April 2025.
Is it a fact, Mr. Doctor?
But I tell you, Lordship Miller, the dates, there's no dispute on that. What happened is, Miller, there was a show cause notice issued in the year 2019. When a managing committee was surviving. Now, Miller, during the challenge to the show cause notice, there are various orders made. I'll not trouble your lordship with those, Miller. Miller, the term of the managing committee ended. Thereafter, Miller, on 1st of March 2020,
Yes.
But on first of March 2020, Millard, the next managing committee comes. Whose term has ended in February 2024. No dispute on that.
25.
Sorry, 2025.
Yes.
Manoj, the challenge to Millard, the show cause notice was taken up to the Supreme Court. Before the Supreme Court, Millard, there was an interim order. To the extent that you reply to the show cause notice, the administration will take a decision on that, but the decision will not be given effective.
No, but Mr. Dotto
Yeah,
is not a director. How can he affirm the affidavit also?
may I say this, Millard?
He has affirmed it on 1st of April,
Yes, yes,
claiming to be the director of the petitioner number 1.
yes.
He no longer is the director.
No, I tell you, Lakshman, thereafter what happened is, Millard, they have passed this supersession order.
I will give you leave. You file fresh, withdraw this by the appropriate person.
No, there is another petition over here in person. He's the petition number 2.
Petitioner number
2.
read petition number 2.
Yes.
এটা হাইয়ের অর্ডারটা
হুম।
পেজ 63 আর লাস্ট পিটিশনের অর্ডার 273
There is another one, Mr. Shamol Halder is the petitioner number 2.
He's only claiming to be director, my lord.
He is claiming to be the director.
He's a member also. He's a member also.
He's not a director anymore. That is the whole point. He's a the affidavit as a director, not he can file as a person agreed, but not as director.
Mr. Dotto, you take it back and file.
No. Well, many things are happening in the meantime. I'll tell you, Lakshman.
No, but we'll
At this point, they cannot take this point before the Supreme Court, we had challenged it by way of Article 32. In the Article 32, the Supreme Court says, why before under Article 32 go before the High Court?
same persons.
Yes.
But Supreme Court was, that was not.
No. Because I'll tell you why. Because before that, unfortunately, that order is not on record. When we were litigating before the Supreme Court, the same submission was made before the Supreme Court that the tenure of the managing committee is going to come to an end in February 2025. And when the administration was directed by the Supreme Court, that soft copy of record. The administration was directed to take instruction on the matter. Then when the matter was made returnable by the Supreme Court, to take instruction on the expiry of the term of the managing committee, on the returnable date, they do not say anything about anything. They make a prayer that we have taken our decision on the show cause notice. Kindly give us the liberty to communicate to this to the petitioner.
Who, or they say, bank says.
Bank says. Now, I'm the bank, the RCS says.
Administration.
Then the Supreme Court allows them to communicate the order. It's not a communication as such because it was annexed to the application, interim application that they have made. And Supreme Court has stayed the operation of the impugned order for a period of 6 weeks, which is going to expire within a few days. 16th of April. 16th or 17th of April, it's still surviving. And the Supreme Court gave us liberty to file appropriate proceedings at the appropriate place. But we file an Article 32 in challenging the supersession notice. Supreme Court says that don't come under Article 32, your remedy lies under Article 226. Therefore, we are before your lordship today. Now, kindly have a look to the Supreme Court.
Mr. Doctor, how he can say all these things? He is not a director.
But petition number 2 is one of the members.
He's not a member. He's representing the bank. The director. There's a wrong thing which has been stated by him.
No, it is not
But he's not a director after 20 years.
Please consider Article page 275. Can you have a look?
200 and
275. But before that, can you permit me to place the soft copy of an order?
আপনি চাইছিলেন
No, we understand that, Mr. Dotto, that the Supreme Court said that you communicate the decision, then they will put.
Yes,
You
yes.
did so, but by that time, when the 32 was disposed of on 7th March,
27th March.
27 March, at that time also, you were not the director, anyway, the limit point was not taken. But
Yes.
today, when you are challenging the order, it must be challenged by the director of a bank, or it has to be represented by, I don't know. what I-
Yes, so challenge, my respectful submission is it can be challenged by a member also.
So you challenge, you change your nomenclature, you have described yourself as a director of the bank.
Can we have a look at the cost title?
Yes, Shamul Kumar Halder,
Yes.
director of Andaman and Nicobar. That you proceed, if you are a member, you can ventilate this, you ventilate, come tomorrow with the petition. But how can you, this director can?
Because I have described myself, petition number, do any wrong of the elected and the level, no, I cannot remember actually.
Plus petition number 1 also has to go. Petition number 1 cannot file.
No, that your lordship can direct me.
Why the bank will go?
Because the bank is no more in their control, my lord. So they are challenging, my lord, as a
No, no, it cannot be.
The bank is being represented by
No, bank.
any administrator.
Because the bank, they are no more in control of the bank. So, my lord, it is like a IBC proceeding, my lord, where, my lord, the board is suspended. So then after that, a person may be.
That Mr. Dotto will think, will take advice.
There is no scope of appointing an administrator also. The rules, what here does not prescribe for appointment of an
Mr.
administrator.
Dotto, you are protected till 16th. You take it back and file a case tomorrow, it will appear.
না তোমাকে মামলাটা ফাইল করতে হবে
Mr. Chakraborty is here, he will be
Yes,
representing the defendants.
Yes, yes.
So you file it, give a copy to you and come back to me. Today we are on, today we are,
Friday.
today we are 4th.
Fourth Friday. No, I have time, I can come back next week.
You have to come back again.
Hmm.
Is the problem.
No, no, I may grant me that.
Mr. Dottul and a senior advocate appearing for the
Item number 5. W 8 of 2025.
Well, after the petitioner.
I appear on behalf of the respondent. Your
Item number? Yes, madam.
Here, my lord. I have applied for notice and encumbrance certificate. Here, my lord, in the silent mode, prior to sale deed, we have to first take a no dues, non-encumbrance certificate and valuation certificate. Thereafter, we have to get a sale permission from the deputy commissioner. Then the sale deed has to be executed after following all these formalities. But no dues, non-encumbrance valuation, that is not there under the law.
Pardon?
That is not there under the law. That is the practice.
No due?
No dues,
Sorry.
encumbrances. No dues, any dues are there or not? Any encumbrances are there on the land?
To that effect, you have to furnish a no objection.
Furnish a no objection by the, no, my lord, no dues and non-encumbrance has to be furnished by the authority if I apply. My lord, that has been rejected. That is the thing there.
So you applied for a certificate, no due certificate, and applied for permission.
No, no, yes, my lord.
You applied for permission to sell the plot from the deputy commissioner.
No, my lord. Now, no, for reaching to that effect, my lord, we have to go through this no dues, non-encumbrance and valuation. Then only I can take permission from the DC. Before that,
Just no due, no encumbrance, and
valuation certificate.
yes.
But under the law, it says, as per section 159, only I have to take the permission from the DC. If I want to sell or gift, I want to gift or sell. Prior to that, I have to take permission from the deputy commissioner. That is under section 159.
Regulation 150.
Regulation 159. Only that much is provided in the regulation law. In 59(9), subclause 9. This interest of license of a non-agriculture, this is for non-agriculture land. This is for the non-agriculture land of state permission. Shall not transfer except with the previous permission in writing of the deputy commissioner and subject to such terms and conditions as may be prescribed, as may be prescribed. So this is the law. But there is a practice, prior to this, they are saying to take notice and encumbrance certificate.
So when you are saying this argument you made that no due and valuation is required.
That is the practice.
So say that you are saying you started your argument saying that 159 does not provide for any such condition of a no income certificate.
Yes.
That is not spelled out in clearly.
Yes.
It may as may be specified. As may be specified. Yes. Now what happened? You applied.
My lord, I have applied. My lord, here the petitioner is the joint recorded tenant.
Joint
He is the
recorded
tenant.
along with whom? Another person.
His sons.
Along with her sons. So she then she alone is seeking permission
Permission.
for and on behalf of everybody.
No.
Then
Her share.
for
Her
her
to give her share.
I see.
For that reason, permission is required.
Yes, very good. Then proceed. What happened? Where is your page 20 is the form F under Rule 130
My
record.
lord, and page 20 is the form tab
Her name is recorded along with others.
along with the others.
Next.
Now come to the map, my lord.
No. What is this record of holding register? What is this?
This is the ROR, my lord, wherein the my name as well as the others' name.
Where do we find that?
My lord, it is there, my lord. Name of the tenant,
Is only where?
second column, my lord.
Only son of Abdul Malik.
No, my lord. First page continues, second page also, my lord.
Oh, I see.
Second page continues the first one.
Achha, very good. So you are the owners and recorded tenant.
No.
Then
is this sketch map, my lord, 22. Page 22 is the sketch map wherein 666/1/2.
666 oblique.
Big 1/2 surrendered by all survey numbers.
Huh.
They are the actually the relatives of the
Very
petitioners.
good. Then what happened?
My lord, she has applied, page number 23, my lord. She has applied on 11th of October 2023. She got
11th,
the permission
11th of
of
October.
October 2023.
Land
But
discipline.
this-
Just a moment. Just a moment. Yes, then
My lord, here, it's my lord, last line. This certificate is valid for 11th October 2023 to 10th April 2024. So, my lord, if she has to execute a sale deed or a gift deed, she has to do within the 11th October because the permission is up to 10th April 2024. My lord,
so he has to do within 10.
within that day. So, my
No,
lord,
no, within the means after 10th it will expire.
it will expire.
Yes, now
In those periods, she could not manage the stamp duty and all. So thereafter, again, she has applied for the same thing because the expiry, after expiry, she has to file the fresh one.
where is that?
That is the 24, page 24. My lord.
Page 24.
My lord. It was filed on 11th of December 2024.
Hmm.
My lord, it was rejected on the ground that, kindly be seen, my lord, last, right hand side last, my lord. It's a rejection. As per report of the Tehsildar, the subject land is not free from all encumbrance.
Hmm.
It is mentioned, my lord. My lord, earlier it was issued. Earlier it was issued the same.
So,
Same certificate.
what appears is there may have some encumbrances have
There is no
Right.
that. No,
in between, strictly speaking, some encumbrances may have occurred on and from 11th April 2024 till 8th January 25. That is
encumbrance,
maximum that can be sent. Yes.
encumbrance means, my lord, any dispute.
Uh-huh.
There is no dispute. There is no suit is pending.
Now, what happened, madam? Then why you, what is the encumbrance?
Receive the copy of the writ application. Let this matter be fixed on Monday, my lord. I'll come back with necessary instruction, madam.
But this was there yesterday in the list, no?
But today I have received the writ. They have given me the copy of the writ application today morning.
So you ask your Tehsildar what is the encumbrance?
Yes, my lord, because maybe after 10th of April 2024, something might have happened. Maybe it has been
No,
modified.
but thereafter he made representations to a senior officer and the member,
the MP and all.
legislative member has also sent, he has written.
Yeah, my lord, assistant commissioner has said that the area which is there,
Hmm.
now it is beyond that area, 690 square meters are possessing.
Where,
It is there at page 28,
page 28.
Annexa PC. This is the letter of the assistant commissioner, South Andaman.
Yes, what he has
The
said.
last paragraph kindly be seen.
Hmm.
Further, based on the field inspection,
Hmm.
it was found that a Kacha house of 92.9 square meter and semi-RCC residential structure of 164.8 square meter stand on the aforementioned land. Additionally, the inspection revealed that approximately 690 square meter of land is under the possession of the recorded tenants, which exceeds the area mentioned in the records of rights.
Why, what is the area you are
I'm
in
possessing
your record?
79. I'm 579 square meter.
570.
This inspection, they are saying inspection was done. This has to be done in presence of my client, madam. This was never done, madam. This was never done. And moreover,
No,
madam,
then additionally, the inspection is approximately 690 square is under possession of the recorded tenants, which exceeds the area. Thus, the concerned land. So, then why did you give him the income? Why did you issue him the certificate? Go back on.
Earlier,
Earlier means not only earlier,
before 10th of April.
it was on.
It's clearly mentioned that during the field inspection that was done after 10th of April.
How do we know that?
That's,
Date is not given.
Date.
Date is not there. Thus the
It's in
connected
the
land
month of February
bearing.
only, I believe.
It has been given in February. Excision area, then does the bearing survey number eto is found, why not free from encumbrance, which has resulted.
In rejection of the non-encumbrance certificate.
What is encumbrance, madam? Encumbrance is when my property is subject to any sort of.
She is under unauthorized occupation of the excess area. She.
So you
she was
remove him,
found-
we will say no encumbrance only for 590. You remove him from there.
579.
Huh?
579.
570, only ground is she is holding excess land, she is holding.
Yes,
So that is not my encumbrance, my lord.
Wait, madam,
Sorry. my lord.
we will give you liberty.
my,
I shall direct you to issue the no encumbrance in respect of that portion of land.
my lord.
And if he is in illegal possession or if any excess land is being held by you, you would be at liberty to take appropriate steps.
My,
So that will follow along with the, if he sells it to somebody, he will also be subject to this rider.
my.
Can, I'm passing the order.
Yes, my lord, that can be.
My lord,
If she is found in excess area, then she can be removed.
No, that is why I
For
wanted.
that reason only, it's like we
Yeah,
cannot
madam, you
issue
take-
the non-encumbrance, my lord. Because
No,
she is.
non-encumbrance is what? Suppose it is it is when it is saddled with some sort of negativity, the land, saddled with something. Here it is not that it is under the mortgage. It is not that it is somebody else is occupying. It is also not that they are not the recorded tenants. So what can be the encumbrance? The meaning of the term encumbrance is to encroach upon somebody's.
Land.
So
Here
this
also
is
she
the
has-
case is it is not an
She
encumbrance,
has
but it's an.
exceeded her limit.
Huh?
She has exceeded her limit.
We will say that
Right.
she will get permission only to the extent of her recorded land of 0.59.
my lord.
You talk with your officer, come back to me. Pass this order.
Right.
And you, in the meantime, you take note when the inspection was conducted.
When it was conducted. I think it was conducted in the month of January or February maybe, because the order was issued in 10th February 2025. Maybe January after 21st January.
In presence of my client, which was done. How he has done, my lord? Tahsildar, if he is entering my premises. Inspection, how he has done that, also, my lord, that report. They are saying they have done the inspection. my lord.
Mrs. Gillian, the advocate appearing for the petitioners, submits that the petitioners are
Item number 6.
My lord, this is an application what they have filed for water tap connection as a domestic water tap connection.
Yes, yes.
Yesterday, my lord has told me to take instruction. I take instructions, no? It can be considered not subject. They have to fulfill the requirements has been raised by the authorities. My lord.
What requirement?
Lord, they have to show it the Aadhaar card and the residence because sometimes what happens when the order has been passed, but the authorities are going to search out the possession, they are not found in the possession. So this is a difficulty. If they show it that Aadhaar card or that they are residing on a subject landed property, then they have to show an affidavit also that showing an affidavit they will not claim any right title by virtue of an encroacher. They are basically an encroacher. They are claiming for a water tap connection.
So what did your officer say?
But they say they will consider it.
I consider it, he filed it in February 25. Why you have not done?
But they have not submitted any document to that extent. That required documents which has never been submitted.
Which document is required?
That Aadhaar card and the Islander card.
Page number 11, it is 7 of the writ petition, it is Aadhaar card is there, the same address of the
Let them submitted that to the authorities. We will.
the ration card also there. We have submitted the Aadhaar card, ration card Xerox and the voter ID card and the no objection certificate of Gram Panchayat also with the application.
They say only an application has been online application has been uploaded without any supported documents. So that is a difficulty. They say they will consider it.
So what they will do if you do not provide online updatation of any further document, what they will do?
Some attachment was given in the online. They have to attach the documents, you know, the support of
Online.
Yes.
Online.
There is an option because they have not done so that I have taken instruction. This was and authorities have instructed me that they have not supported with any documents.
Then how can we submit
Not-
now online?
Only pass and direction that within a fortnight we will consider that case in accordance with the law. Subject they deposit the amount which is will required to be give the water tap connection, which will be assessed by the authorities. Let that order along with the writ petition can
Who
be
is
served.
the authority?
No, it should be that assistant engineer PhD. Respondent number 3. The document is not there,
Ashok, Miss, what is your name, madam? एफिडेविट से तो काट दीजिए।
Item, item number 7. WPFP 324.
But we all feel hungry. We come to court at 9 civil cases, we all do.
All right, all right. Yes.
Lord, in the year 1988, he was initially appointed.
88.
88 on temporary basis. Subsequently, my lord, on and from 13th of March 1989, he was appointed as assistant grade 3,
13th of March
1989.
89.
My lord, as assistant grade
Assistant grade 3.
3.
Yes.
Subsequently, after rendering service for 3 years and obtaining the diploma and all, on 21st of April 1992, he was appointed as senior grade 2 caretaker trainee, my lord.
Yes.
My lord, once he appoints to the said post, my lord, he has to undergo training for a period of 1 year. And within that period, my lord, an examination will be conducted. And after the examination, he will be appointed on regular basis.
Regular basis, money regularly in the post of senior grade 2
Caretaker. Now, my lord, here, due to the fault on the part of the authority, my lord, that examination was not conducted within a year. As a consequence of which, my lord, this trainee period prolonged. And his service was confirmed on and from 3rd of November, 1995.
He was confirmed in the
Yes.
said post.
Yes.
It took about 3 years.
3 years. Now, my lord, this is one of the case made out by me that due to the said
Fault of the employer, you cannot suffer.
my lord,
For the fault of the employer, you cannot suffer.
I cannot suffer. Because of which my subsequent promotions
Were deferred.
yes, deferred. Now, subsequently thereafter, my lord, one more promotion is there, which is this. Both are the subject matter, my lord. Subsequently, my lord, in the year on 3rd of February, December 2012, my lord. 3rd of December 2012, I was promoted to the post of senior superintendent, housekeeping, senior grade.
That is about 17 years.
Yes, my lord.
Then what
This
happened?
was done, my lord, by order dated 27th of February 2013.
27th February 2030.
Before that, he was superintendent housekeeping.
Now, my lord, and this scale of pay in number 17, I have stated. In paragraph number 17, I have stated this. And my lord, the scale of pay was 20600 to 46500.
Of the of the
Senior superintendent.
keeper.
Senior, yes,
Housekeeping.
senior grade.
Yes.
This is the salary of the executive, my lord.
This is a senior superintendent housekeeper.
housekeeping senior grade,
Huh.
and the salary is at par with the executive post of assistant manager.
Yes.
Now, my lord, at that point of time, he was getting this scale of pay, and the pay is equivalent to the
Assistant.
manager, but the other service benefits are not accorded with regard to the post of assistant manager.
There is other service benefits which were there in housekeeping.
No other service benefit which are there for the assistant manager, like dearness allowances, extra. What?
Oh, acha,
Yes,
acha.
that I have not been given, my lord.
You were only given the scale.
Okay.
Yes.
Now, my lord, after this, on 15th of July 2022, my lord, the respondent authorities issued an order whereby promoted me to the post of assistant manager
With effect from that date.
with effect from that date. That
The
is,
15 July 2022.
no,
That
with
is,
effect from that date when I was promoted to the post of housekeeping. That is,
it is 3rd of December 2012.
even prior to that, 26th of October 2012.
But you were promoted on 3rd of December,
Yes.
you said.
They have given this benefit from
Via memo dated 15 July 2022. That is page
57,
57.
my lord.
You have been given the scale.
Yes, I have been promoted. It is written, I am just reading it, my lord. Page 57.
বাবা, এটাতে একটু জল দাও না। এটাতে একটু আর এই পেন্সিল গুলো একটু সাফল করে দাও। Page 57, yes.
57, my lord. It
Yes.
says, my lord, it is, my lord, will get the date at the right hand side, my lord, 15th of July 2022.
Yes.
Yes. It says, my lord, in continuation to this office order dated 26th of October 2012, and on the recommendation of the duly constituted review DUPC, the competent authority has approved the promotion of following senior superintendent housekeeping to the post of assistant manager housekeeping on regular basis in the pay scale of rupees so and so notionally from 26th of October 2012. And the actual financial benefit with effect and from taking over the charge of higher post.
Fair enough.
Yes.
When
Now, my lord, my name appears at serial number 16, man.
Prakashan.
Yes. Now, my lord, I taken the charge on 2nd of August 2022.
Second of
August 2022, my lord.
very good.
So from that day, I have got the
Actual benefit.
actual benefit. Now, my lord, as per the recruitment rule governing the affairs, the incumbents, there are promotion avenues, my lord. How a person would be promoted and what would be the requisite length of service, my lord. My lord, may may kindly come to page 20, my lord.
Page
20, that is in my pleadings, my lord. Page 20, I have said, my lord.
So you are claiming retrospective benefit in respect of the posts.
My lord. And I say one more thing, my lord. I seek parity.
That's a page.
Page 20.
Just. paragraph 38.
My lord,
You have given the requisite length of service.
length of service which is required. Now, my lord, I am assistant manager.
Hmm.
Now, my lord,
So you are working as assistant
assistant
manager. You
manager,
are-
I am going to retire this month from service. Now, my lord, from assistant manager, next promotion post is manager, thereafter senior manager, thereafter assistant general manager, deputy general manager.
Now you are already, you are assistant manager now.
Yes,
That is page 57 you showed.
my lord, my lord.
That you are the,
Assistant manager, housekeeping.
you are the assistant manager housekeeping. Where is that post? In this hierarchy, page 20,
That is at the top, my lord.
clause 4, assistant general manager,
Clause 1, my lord.
assistant manager.
Yes.
Acha, acha, acha.
Now, my lord, these are the promotions
Yes,
which I am claiming. I am claiming
this promotion.
these promotions. And what are the ground, my lord?
No, you are claiming from which date?
I-
You have been given the post of assistant manager with
In 2012.
retrospective effect.
With in 2012.
12 notional benefit,
Yes.
actual benefit from the date of death.
Yes.
Now you are going to retire when?
30th April, ma'am, this month.
On 30th April.
My claim is, my lord, 2012, I became assistant manager. 2015, I qualified to be manager. And likewise, now, my lord, here I am claiming parity with those who were appointed along with me and who were junior to me. But they were given timely promotion, as a consequence of which they got the promotion of director general, deputy general manager. I have includes all those documents.
Yes, because where is that averment of yours?
Yes, my lord, averment is there.
Para 44.
No, prior to that also it is there, my lord. If my lord sees para 44, it is specifically stated. Apart from that, it is there, my lord. I will show. Para 33.
So why didn't you come at that juncture? When your promotions, when juniors were
No, I
given-
have made several representation before the authorities. My lord, I approached the tribunal, tribunal, my lord, wrongly. Tribunal without jurisdiction, tribunal has rejected. Thereafter, I approached this court. My lord, may kindly consider, my lord, there are two parts. First, my lord, I was not at fault. Second, my lord, they have given me the benefit not.
when was the tribunal reject?
My lord, tribunal rejected.
Tribunal did not decide.
27th of,
Not decided.
27th of June.
Jurisdiction, 27th of June, 2020,
2020.
page 106.
Page 106. 24th of June 2024.
Yes.
You filed it when? Which year?
It was filed in the 2024 only.
Immediately I have filed.
2024 only it was filed.
Oh,
Today.
page 106.
Now, my lord, this discrimination.
You wasted your time there. Tribunal.
My lord. There also they have submitted reply and all there. My lord,
Now-
33, my lord will find. Para 33, I have taken this stand of discrimination, and my lord may kindly come to para 34. 34, several subsection clauses I have given and I have narrated, my lord, how discrimination was made.
Para 34.
34, page 16, my lord, of my writ petition.
No, this act of discrimination you have argued
And
in
my lord,
2024.
my lord, I have specifically stated, my lord may kindly have a look to this, my lord, that the petitioner was
You were appointed as assistant manager.
2022, my lord.
But with effect from?
With effect from 26th of October 2012, my lord.
Very good. Yes, what you want to show? Page.
No, my lord, may kindly see para 34, my lord, my case is there, my lord. It says that the petitioner was appointed as assistant group grade 3, group C in 13/3/1989 on regular basis, having education qualification of graduation in commerce. And one PG Anand Kumar of National Airport Division was appointed as radio cleaner, group D, on 10th May 1989 on regular basis. And is having only the qualification of All India Senior Secondary School examination. This is first. Second, the respondent authority promoted PG Anand Kumar to the post of superintendent in the year 1996. And the petitioner was promoted to the post of superintendent only on 3rd November 2002. After more than 6 years from the date of promotion accorded to PG Anand Kumar. Anand Kumar is junior to me. He is having lesser educational qualification than me. I can show from seniority list.
So he was under superintendent in 1906.
96.
And
I got in 2002.
no, you got in 2002. You did not say. Tell me.
No, my lord.
Senior grade to
No, my lord, that
grade
is
to caretaker was from 92.
92. Thereafter, in between, this
It
is
was confirmed in 95. When did you get the post of superintendent?
superintendent on 3rd 11 from 2002.
No, third.
No, that I have not stated, my lord, because that was in
Yes.
between. That was in between.
You got 3rd November.
2002.
You were given promotion as superintendent.
Superintendent.
Then you got senior
Yes.
superintendent. Then you got assistant
Yes.
manager. Now your argument is a person junior to you superseded you.
Here and having lesser qualification, who initially appointed in the post of Group D with All India Senior Secondary School examination.
Very good.
certificate.
Then how did they come within the same seniority list? You were a
Initially-
different post.
No, initially, no, my
You
lord.
were appointed on regular basis in commerce as an assistant grade 3.
I had the qualification.
Whereas
that
he
is
was appointed as a group
Group
D.
D. Group D.
It was separate
Separate.
category.
But that time, my lord, they might have maintained because I have seniority list. I can place the
No,
seniority.
no, seniority list will be pertaining to the respective cadres,
Cadre.
not in
No, this
respect
was
of.
within one cadre, perhaps, my lord.
No, no,
My
it
lord,
was
can
not.
we come to next.
You also forgot, see, Mr. Kumar,
My lord.
that you are coming forward, making your adventurous attempt, anyway, we will consider that. But you are badly saddled with time, Mr. Kumar.
My lord. My
How
lord.
can we help you? Tell us.
My lord, once my lord, I complete this para 34, thereafter.
No. I'm not saying
Yes.
that. I'm saying.
No, my lord, the judgment of Supreme Court in many cases says, my lord, latest judgment is also there.
Yes, you
Yes.
place. So your paragraph 34 is the discrimination.
Discrimination, my lord.
Is it pertaining to the same Anand Kumar or
Yes.
some other
Hey,
person?
Anand Kumar.
Acha, then in 2015, a common
seniority list was
superintendent was maintained by the
superintendent housekeeping was maintained by the Airport Authority of India, and in terms of the said seniority list, the name of PG Anand Kumar having education qualification of All India Senior Secondary School examination and diploma in sanitation was figured at serial number 4, and his date of appointment is 10th May 1989. And at the same time, the petitioner who is having graduation degree and diploma in sanitation appointed on 13th of March 1989 was figured at serial number 7 due to the fault on the part of the respondent authority. Admittedly,
yes.
from the said seniority list, it clearly reflects that the service of PG Anand Kumar shows in housekeeping division as on 1/1/2015. That curiously enough, in the seniority list of superintendent housekeeping prepared on 26th of March 2018, the name of Anand Kumar is not figured.
No, earlier one was seniority of superintendent. Housekeeping.
Superintendent. Yes.
Now in clause 5, you are saying seniority list of superintendent housekeeping
Yes.
prepared. This is the first seniority
Yes.
list. He was 4
Yes.
and you were 7.
7.
Now in the next seniority list.
His name is not appearing.
Acha.
Yes. Thereafter, my lord, they say respondent authorities by acting arbitrarily allowed one PG Anand Kumar, employee number so and so, senior superintendent housekeeping, to the post of deputy general manager in operation department instead of housekeeping, and at the same time denied the same to the petitioner who is otherwise eligible for promotion to the said post.
That is deputy general manager.
Manager.
So
You-
deputy general manager is
My lord, that hierarchy.
subsequent to the post of
Yes, my lord, page number 20.
deputy general manager is the highest post.
Highest post, my lord, which I am claiming. Which I am claiming. Deputy general manager.
But where is the superintendent post? You have not mentioned here. Assistant manager housekeeping, manager housekeeping.
Yes.
So you were assistant manager house, you were initially assistant grade 3.
Yes.
This is assistant manager housekeeping. That
Yes.
is 89. But the nomenclature does not tell you. It is assistant manager housekeeping operations.
Yes.
Then manager housekeeping.
Yes. My lord, they have 3 wings, my lord.
Assistant
Operation, housekeeping
manager.
and announcers.
So deputy, please read.
Yes.
Then you see from senior superintendent, he was given deputy general manager.
Yes. Yes. Deputy,
You were not given that post of deputy general.
no, still assistant manager, my lord.
Hmm.
That during the year 2008-9, 5 number of persons, namely J.R. Anup, Shibu Kumar, Naveen Jaful, Srimati Sunita Varghese, Lakshmi, were appointed to the post of junior executive terminal on regular basis under the respond number 2. Subsequently, after their appointment within a span of 3 years, they were given promotion to the post of assistant manager operation in operational department instead of terminal, and as a consequence of which they got further time-bound promotion in the operational department, and presently they are serving as deputy general manager in operational department, and at the same time the petitioner was stagnated. Now, my lord, my case is that, my lord, there are 3 wings: terminal, operation and announcer. Now, my lord, they appointed these 5 persons in
Just a moment.
terminal,
Operation
operation and announcer.
and announce.
Yes.
Sorry, housekeeping, operational and announcer, my lord. Terminal, housekeeping, operational and announcer.
Very good. Terminal, housekeeping and operation and announcer.
Yes.
These are the 3 broad branches.
Four. Terminal.
Oh, 4. Acha, housekeeping. So your allegation is that though they were inducted as assistant manager operation in operational department
No,
instead of terminal.
No, they were engaged in the department in terminal, and subsequently they were accorded promotion in operational.
No, very good.
Yes.
Instead of terminal.
Terminal. Now, my case was,
You were in terminal.
no, I am in housekeeping, my lord.
Oh, you are in housekeeping.
Housekeeping. But what I am saying, my lord, a stand was taken by them. These are the 4 different wings. Therefore, it cannot be interchanged. So I said, my lord, I am saying that the persons who were appointed in terminal, subsequently they were given promotion in operation, different wing. So why can't my case be considered? Why in my case such discrimination was made by them?
Can these be considered at this stage, Mr. Kumar?
My lord, PG Anand Kumar has got all the benefits. I am placing, my lord, the documents, my lord.
Yes.
My lord, my respectful submission is that no harm will be caused to anybody. Rather, it is a continuous wrong which is caused to me, and that gives a continuous cause of action, my lord. Without affecting the right of any third party, my lord.
Yes.
Now, my lord, thereafter I have narrated 2 more incidents, my lord. That though directly 2 persons, namely so and so were appointed as executive housekeeping After discharging 3 years of service, they were promoted to the post of manager operation under the respondent authority instead of housekeeping. So from my stream also, those who were appointed under the housekeeping department, they were also given promotion in the operational department. Now that the respondent authorities are mounting their promotion policy as per case to case, whenever they want to accommodate any person, they accommodate from one department to another department. At the same time, in order to deprive a person, they take the stand that the housekeeping and operational are two different departments and therefore promotion cannot be accorded.
Hmm.
Now, my lord may kindly see the promotion order of Anand Kumar, page 64. He was also given promotion retrospective effect like my client. My lord.
Page 64.
64 million. It is a letter dated 24th of April 2023, my lord.
Promotion to Anand.
Yes.
Yes, what you want to show?
It says, my lord, in continuation of this office letter dated on the recommendation of the duly constant review DPC, the competent authority has approved the promotion of following assistant managers to the post of managers on regular basis in the scale of so and so with effect from 31st of December 2009, my lord. Anand Kumar name appears at serial number 2. PG Anand Kumar. So he was promoted to the post of manager, giving retrospective effect from 31st of December 2009. Now, my lord, on the very same day, my lord may kindly come to page 66. 65 is the original document, my lord. This is typed document, page 66. It says, in continuation.
No, he was given from assistant manager to manager.
Manager. Thereafter, my lord, on the recommendation, has approved the promotion of following manager to the post of senior manager on regular basis in the pay scale of rupees so and so with effect from 21st of November 2015. Now, my lord.
Where you are reading? Where you are reading?
Page 66.
Typed copy.
Yes.
It says, same day, my lord may kindly see the date, 24th April 2023. It says, in continuation of the office order dated so and so, and on the recommendation of the duly constituted review DPC committee, the competent authority has approved the promotion of following manager to the post of senior manager on regular basis in the pay scale of so and so with effect from 21st November 2015 on national basis. Now, my lord may kindly consider this aspect. On 24th of April 2023, that person got 2 promotions.
Notional basis.
Notional basis.
So he was given the post of senior manager with effect from 21st of November. He was given the post of as manager.
Yes.
With effect from 31st of December 2009. And you were also given the post of
Senior manager.
No.
Assistant manager.
It's a
No, you were promoted to the post. Where is this page?
Page 57.
Page 57.
Yes.
You were promoted to the post of
Assistant manager.
housekeeping.
Assistant manager housekeeping, yes.
So, and your counterpart got as post of manager operation.
Yes. Since he was already promoted to assistant manager, therefore he was promoted to the post of manager operation.
Yes, all right.
And subsequently, on the same day, he was promoted to the post of from manager to senior manager.
With notional basis retrospective.
My lord, I am also seeking the same. I say that
why they are not giving it to you?
Yes,
Please an answer.
now they have to answer. Now, my lord, may kindly see page 67. The list, my lord. This is of 2005. No, my lord may kindly come to, I will show two more documents from this and thereafter I will show documents from their.
Page 67.
No, my lord, I will show from their document, from their seniority list, yes.
No, this is your serial is 21.
No, I will show from the seniority list which my learned friend has enclosed, 2015. Now, my lord, may kindly see, I have made an application under Right to Information Act, page 59 and page 60. I have sought for certain information from the authority, my lord.
59 and 60.
60. My lord, this was immediately when I was promoted to the post of assistant manager. Thereafter, my lord, I have made this application before the authority in order to ascertain as to why I have been stalled. My promotion was stalled, and at the same time, PG Anand Kumar has got. Now, my lord will find. I have asked this document. Their answer, my lord, may kindly see. They say the custodian of the information is so and so. Thus, the same is being forwarded. No information was given. Permissions.
What was your query? Copy of court case?
Court case with regard to the court case between PG Anand Kumar and Airport Authority of India. Thereafter, file noting in respect of promotion dated so and so in respect of PG Anand Kumar. Thereafter, copy of merger seniority list as mentioned in promotion order dated so and so. Copy of Kerala High Court final verdict in case of so and so. Thereafter, my lord. Once again, I have made the same, my lord, two of such information in page 60. I have asked for the under the Right to Information Act. Now, my lord may kindly see from there affidavit. This is the seniority list, my lord, page 27 of 2015. Affidavit in opposition.
Page 20.
Page 27 of the affidavit in opposition.
Page 27.
Well,
Yes.
my lord will find at the top common seniority list of superintendent housekeeping as on 1st of January 2015. Now, my lord.
No, these divisions, housekeeping terminal, 4 divisions which you said. Your initial induction was in housekeeping and you have continued
Yes.
it. And Anand's induction was in
Operational.
operation. Your statement in paragraph 24.
I said, my lord, he was appointed.
Just a moment. Where you have that is
Page 16, para 34, small I.
page 20.
Rather than in para 33, I have categorically stated he was appointed in housekeeping.
No, he was placed as a group D, as
Yes.
radio cleaner group D.
Yes.
Radio cleaner group D is in which category? Housekeeping?
No, my lord, I say because in para 33, I said housekeeping.
Para 33.
13 line from the bottom, my lord. November 2021, full stop. That the same time, one Anand Kumar, employee number so and so, is also from housekeeping department, having only qualification of 12th standard, was promoted time.
So he was taken to other operation.
Operation. And my lord, now my lord may kindly see the seniority list at page 27. Under the heading, common seniority list of superintendent housekeeping. Housekeeping as on 1/1/2015. My lord, Anand's name appear at serial number 4. PG Anand Kumar, and his qualification is higher secondary, it is written there, ma'am.
Yes.
Date of engagement is there, my lord, on 10th of May 1989.
Hmm.
And my lord may kindly see my name is at serial number 7. I am having BCom, diploma in so and so, inspector course, MBA, and my date of engagement is 13th of March 1989.
So what is the wrong? He was an older person than you.
No, my
His date of birth.
older person, if both the persons are appointed on the same day.
No, they were not. They on the
I was appointed on 13th of March 1989.
13th of March, in an assistant grade 3.
Yes, and he was appointed on 10th of May 1989. Initial inception in service. I am senior.
Hmm. So this is under the section of housekeeping.
Yes, housekeeping. Now, my lord, I will place paragraph number 3 of my affidavit in reply, and I will place one document.
So what is their answer in the opposition?
They, my lord, they say that this is the mistake committed by us. They have been.
Mistake.
No, never said that.
Kindly-
So that she will point out.
Yes, yes.
Take us to the reply.
Yeah, they are replying, my lord. Yes.
Your
No,
reply.
yes, my lord. My lord.
You want me to show anything
Yes,
else?
affidavit in reply, my lord. My affidavit.
Nothing from the opposition? Affidavit in reply, yes.
Yes. My lord, para 3, my lord.
Hmm.
Paragraph number 3, my lord will find that this would be the repetition what I have submitted. My lord may kindly come to page number 3. Fifth line, there are altogether 4 departments under the respond authority. Then those 4 departments I have narrated. Then I say subsequently the respond authorities merge terminal management, operation and announcer, but the housekeeping department was not.
Here the matter is.
As a consequence of which.
Here the matter
As
is.
a consequence of which. The
Just one, merge the terminal management, operations and announcers.
yes.
But housekeeping was not merged, as a consequence of which. Yes, in the
The
other.
employees in the other 3 departments got further promotion avenue and they were promoted to higher post. But at the same time, the petitioner was stagnated in the said post of assistant manager, housekeeping from 2012. As a consequence of which, the petitioner made repeated representation to consider his case for further promotion to the higher post and to consider the period from 21st of April 1993 to 2nd November 1994 as regular service for further consequential service benefit. That due to the wrong on the part of the respondent, the petitioner was not given timely promotion, as a consequence of which the petitioner is stagnated in a post of assistant manager under the
So you are still continuing as the assistant
assistant
manager.
manager.
That due to the wrong on the part, not given as a concept, it is stagnated in the post of assistant manager.
Whereas junior of the petitioner, PG Anand Kumar, who was accorded timely promotion, is currently holding the post of Deputy General Manager, operational under the respondent authority. That similarly, one R. Ravi Chandran, who was appointed on 6th of September 1995, one Supwan Lakra, who was appointed on 19th of January 1996, and Sanitin Mandal, who was appointed on 16 July 1996, and Sri Vidut Kumar Adhikari, employee number so and so. Admittedly, all of them are junior to the petitioner, but were accorded timely promotion, as a consequence of which R. Ravichandran is currently holding the post of assistant manager, general manager. Setilvan Mandal is currently holding the post of manager, and Supan Lakra is.
You are assistant general manager. You are assistant manager.
I am only an assistant manager.
So after that hierarchy.
Manager, assistant general manager, thereafter this deputy.
No, assistant manager, then,
senior manager, then assistant general manager, thereafter deputy general manager. So admittedly, all of them are junior to the petitioner, but were accorded timely promotion, as a consequence of which R. Ravichandran is currently holding the post of assistant general manager. Senthilvan Mandal is currently holding the post of so and so and presently holding the post of manager.
yes,
Kumar joined as so and so under the respondent. At the same time, the petitioner till date is working as under the respondent since 2000. Now, my lord, to substantiate this, my lord, I have placed the seniority list of the managers and all, where from it reflect, my lord, these persons who were inducted in service much after the petitioner. My lord, may kindly come to page 22 of the affidavit in reply. Annexure starts from page 20. This is a circular of provisional seniority list in respect of the managers to AM housekeeping. This is with regard to housekeeping, my lord. Now, my lord, may kindly come to page 22. This is with regard to senior manager. My lord, may kindly see at the top provisional seniority list regarding senior manager housekeeping as on 30th September 2023.
yes.
Now, my lord, may kindly see serial number 3. R. Ravichandran. His initial date of engagement may be seen, my lord, 6th of September 1995.
You joined in
89, my lord, May 1989. So, next, my lord, may kindly come to next page, my lord, page 23. The name which I have narrated in para 3, my lord. Kindly see page 23.
They are all younger to you.
All younger, my lord, and there first I have shown, my lord, the now I have shown, my lord, the seniority list of senior manager. Page 22.
You are not given the senior manager.
No, I am just showing, my lord, they are junior to me. This is with regard to senior manager. Page 23 is, my lord, of the manager.
That also you did not get.
No.
So this gradation list, this is this. Where is the then seniority list pertaining to assistant manager?
Yes, it is there. It is also there.
Where?
It is at page 24. Before that, I want to show, my lord, page 23. First, I have shown, my lord, the manager.
This is manager.
I have page 23.
You have shown senior manager, manager in page
23. Manager, my lord, may kindly see serial number 5. Saman Lakhara, his date of engagement is 19 January 1996. Serial number 9. Sarita Mandal, his date of appointment is, her date of appointment is 16 July 1997. Now, my lord, assistant manager. Now, my name appears at serial number 2, my lord.
Top. Yes.
Serial number 2, my lord. My date of
This is senior assistant manager in housekeeping.
housekeeping. This all are housekeeping, my lord. This all are housekeeping. So, now, my lord, my date of engagement, my lord, it is there, 13th of March 1989. So, my contention is, my lord, those who were appointed in the housekeeping department also, who are much junior to me, they were given timely promotion, as a consequence of which they all reached to the post of either assistant general manager or deputy general manager. But I have been stagnated in a post from last more than
12 years.
12 years. Now, my lord, at the same time, my lord has seen page number 60 and 61, page number 64 and 66, where Anand Kumar, on a single day, that is on 24th of April 2023, he was accorded 2 promotions.
On and from different dates on national basis.
Promotion given to him on nationally, 2009 and from 2015, manager and senior manager.
Yes. Hmm.
Now, my lord, there are two grounds taken by them. One they say that since you are from a different wing, that is housekeeping, therefore it was not considered. First. Second, if my lord sees both the aspect, my lord will find that this that Ravi Kumar or something, my lord, that name, that person, Anand Kumar. Anand Kumar was from the housekeeping. Subsequently, he was given operation and then thereafter.
Then why didn't you protest at that stage?
My lord, I have been given.
Show us one letter that when that is a very serious discrimination. He was lowered in qualification and lowered in tenure.
My lord, 2022, I was given promotion to the post of assistant manager.
No, I'm talking about 89. When you were inducted in the housekeeping branch as the post of that assistant grade
Yes,
3,
yes.
at that time a person having lower qualification and junior to you was inducted in the same section but higher to you. Your promotion was given to him later on.
Yes, to me later on, 1996, and I was given 2002. Maybe. He was given promotion in the year 1996 to the post of superintendent, and I was given in the year 2002. Now, my lord, what I am on, my lord.
Again, you make
No, that's superintendent, my lord.
Superintendent on 3rd November 2002.
Yes, and he was given in 1996. That is page number 17, para number 2, my lord, of my application, writ petition.
No, his induction was as an radio cleaner group D.
Yes.
And you were as assistant grade 3. The assistant grade 3 is a higher post to radio cleaner, must be.
Here it is written, my post was group C and his post was group D.
Group D, then what is the wrong? Now from group D, in radio cleaner group D is in which section?
Operational.
Paragraph number
That is in
33.
operation.
Paragraph number 33.
Let us first.
No, my lord, our contention in para 33 is it is from housekeeping.
The
Paragraph
order
number
speaks.
33.
Yes.
Now from that post, kindly come to page 17.
Yes.
Promoted PV onto this post of superintendent in 96.
Yes.
That is when he was working as group cleaner.
Yes. And I was promoted in the year 2002.
Yes, madam.
No, my lord,
Yes.
only two things I just, my lord, I say, my lord, it's a clear case of discrimination on people. First, if they say that it is operational, suppose their argument, if my lord accept that Anand Kumar was in operation, therefore it cannot be considered. But my lord has found that those who were appointed in housekeeping and those who are junior to me were given the higher promotion post, and at the same time I have been stagnated in a post. That is the affidavit in reply, that list which I have shown to my lord. All of them were much junior to me, but they reached up to the post of assistant general manager and director, deputy general manager. I have been stagnated in a post due to the fault of the part of the authorities. And my contention is that when in 2023, you have given two promotion to a person, as a consequence of which he was able to be promoted to the post of director general, the deputy general manager. Why can't the same treatment could not be given to my client? Because it is in 2023. It is not that. He gets that benefit from 2009 and 2015. But in the year 2023, it was done. My lord, my cause of action arises in the year 2023. When after I was promoted in July 2022, when I was promoted to the post of assistant manager, my lord, thereafter, when in 2023, all this promotion was given to Anand Kumar, then the cause of action arises. I made application, I made representation before the authority.
But that shows clearly is in the assistant manager operation. He was given the post in a separate section or.
My lord, I say it cannot be two cadre. And secondly,
we will inquire from her that how this shifting is done.
Yes. And second aspect, my lord, I have shown my lord this affidavit in reply. That list, my lord, may kindly have a note of this. All are junior to me, but they are enjoying the higher post than me.
How do you answer that other three sections were amalgamated? Only housekeeping was left aside. So when there is an amalgamation of the other three operations and housekeeping does not come within it, there has to be two separate seniority lists in the two factions.
But my lord has seen that in housekeeping, his name is there, Anandraj 2015. 1st January 2015, his in the seniority list, his name appears at serial number 4, my name appears at serial number 7. It is their document, they have filed in their opposition. My lord may kindly come to page 27. Now they will say that it was
27 of your
27 of their opposition, my lord. Common seniority list of superintendent housekeeping 1/1/2015. His name appears at serial number 4, my name appears at serial number 7. How they can say that he was in that cadre?
yes.
And second, my lord, that last affidavit in reply, I have shown all those from housekeeping. Assuming for argument's sake, my lord, negate my first argument that Anand Kumar, you are not alike and therefore there is no discrimination. What about, my lord, this? When these all are from housekeeping, all are junior to me, they are enjoying higher post, I am in assistant.
Then,
This affidavit in reply, para 3 and the document. Seniority list of senior manager, manager and assistant manager. Page number 22 onwards,
now in page 24,
my lord.
which is the seniority list in respect of assistant
Assistant
manager
manager, housekeeping.
housekeeping, where does the names of this Ravi Chandran,
Yes, that, my lord, yes, yes.
Sahan, Lakra,
Page 22. My lord, may kindly come to page 22, my lord.
yes,
22.
that is senior manager.
No, now they are senior manager. Their date of initial engagement may be seen, my lord.
That is much later than.
Yes. That
Now,
is
when this, no, in the page 24, in the seniority list of assistant manager,
right, my lord. Yes.
were they there in housekeeping assistant manager? Must be there. That's why they were promoted to the post of manager and then senior manager.
No, this is, my lord, on this.
Then their name has to be there in this seniority list of page 24. This
No.
is of 2023.
No, my lord. 20th September 2023,
Huh?
when this seniority list was published,
Right.
they were holding, Ravi Chandran was holding the post of senior manager. Therefore, his name is there in the list of senior manager.
Very good.
Yes.
Then you please show.
They were senior manager. So he became senior manager.
We understand. I'm wanting to know that from the seniority list for assistant manager, you had been in this post since the year 1989.
No, no, senior manager, my lord, I became
Assistant manager.
No, assistant manager, I have become under the order, page 57. Page 57 is the order whereby I have been promoted to the post of assistant manager, 15 July 2022, with effect from 26 October 2012.
So, I'm wanting to know that if all those three persons as well as you were in the post of assistant manager, by the time you came to the post of assistant manager with effect from 2nd August 2022, and their promotion was in 23.
Yes.
So I want to know that in between this period, there must have been a seniority table.
That they have to produce, my lord. This I produced 2023 with regard to assistant manager, manager and senior manager.
No, do you mean to say that they were along with you as assistant manager at any particular time?
No.
I say that they were junior to me.
I understand junior. Then they must have.
My lord, I don't have document. I have placed the document of 2023.
You know so much, you don't know this.
No, my lord.
That whether your client on 20 assistant manager, he became on 22nd with effect from 26th October 2012.
Yes.
And with actual benefit from 2nd August 22. I want to know the actual position on 2nd August 22.
Yes, the position is there in page 22. Page 22.
Page 22.
Ravi Chandran, my lord, will find that. Kindly see Ravi Chandran, my lord.
Yes.
Kindly see serial number 10. Date of joining in present grade. What is that? Senior manager.
Date of joining in present is 5th of June 2021.
21. By that time, I was not promoted to the post of assistant manager.
But you came notionally with effect on
That is
26th
notional, my lord,
October.
but notionally, that is on 26th October. My lord, the order was passed in 2022. By that time,
So on 2022, at that time in 2022, these three persons must have been working as assistant manager.
no, Ravichandran was promoted to the post of senior manager on 5th of June 2021,
5th of June 21.
serial number 10. And prior to that, he might be the manager. So there is no occasion on 2022 to be the to enjoy the post of assistant manager, because
At any juncture, they must have been at the post of assistant manager. They were directly recruited.
no, my lord, 2021, when a person has become senior manager, prior to that, he might be a manager. Then only he will be promoted to the post of senior manager.
I think I'm not being able to explain. You have shown us the discrimination aspect of it. I am wanting to know, when you worked as assistant manager on and for the actual basis from August 2022 till date. In 2022, they were promoted from 2021.
Yes. 2021 to the post.
Accepted.
Yes.
So in 2022, when you came,
Yes.
they were not in the picture.
No. No. All of them. My lord, may kindly see, all of them, they were promoted prior to 2022. It is there, my lord, in serial number 10 of all the
So when you were not even born in that post,
Yes.
they were promoted.
And they are junior to me.
Yes, what judgment you want to show?
No, with regard to continuous wrong, my lord, that has been followed. My lord, I can give this. Actually, I didn't brought that judgment, my lord. Tarsim Kumar versus Union of India.
Give me the citation.
Citation I am giving. Citation I am giving.
Acha, you give me the citation later. You are finished.
Yes, my lord. I have
Yes.
finished.
Yes.
Now, Your Lordship, first of all, my first point of argument is that he has come to the Honorable Court at a very belated stage. The first representation Your Lordship will find when pointing the grievances was way back in the year 2023, which is at page 61. On 14th of September
No,
2023, he has
no, madam, he came to the tribunal much earlier.
No, in 2024, he has filed it. The first representation for consideration of his grievance was only in the year 2023,
Where is that?
page 61 of his writ petition.
Page
61
Page 61.
of the original, of the writ petition,
That was on 14 September 2023.
2023. His first representation.
Yes.
Now, how this has happened, Your Lordship, we have to first understand. There are two separate entities. One is metro division and another is non-metro division. How they were bifurcated, let us see. In 1972,
Metro and non-metro.
metro and non-metro. These two distinctions are there. And the writ petitioner, he hails from metro division. And the P. Anand Kumar, he hails from non-metro division. Now we have to understand how this division was done. In 1972, The International Airport Authority of India was
You must
established.
have awarded that in your opposition.
Yes, I have stated.
Will you take me to your awardment?
Yes, yes, Your Lordship, may kindly come to page.
Or you want to argue?
Let us understand first
Okay.
why this has happened. Because he is correct that he was stagnated for a particular post. So let us understand. In 1972, International Airport Authority was established, which was a separate entity under Civil Aviation Department. In which entry level position in housekeeping discipline was caretaker.
Caretaker in housekeeping.
Housekeeping. So the requirement was the candidate should be graduate with 1 year diploma in sanitation, public housekeeping,
Which he had.
or 3 years diploma in hotel management. That was the requirement. Promotional hierarchy for that post was advancement to supervisor, thereafter superintendent, supervisor, superintendent, and senior superintendent, and eventually assistant manager housekeeping. This was the hierarchy
In which he proceeded.
in which he proceeded.
And ultimately got the post of assistant manager actually from 2022.
Actually from 2022 with notional benefit. Now, in 1985, Your Lordship, National Airport Authority was established.
So under the International Airport Authority, there were two divisions. Metro division and non-metro.
No. I'm coming to that. Let us understand. This was a separate entity. In 1985, another entity was formed. That was NAA, National Airport Authority of India. The first one was IAA, International Airport Authority of India, and then National Airport Authority of India in 1985. So, which was managing the domestic airports across the country. Housekeeping was also recognized as a distinct discipline in NAA. Both of them are governed in a different way, Your Lordship.
No, his entry was in 1989.
89.
When there had already.
This 1985, it was established NAA.
Very good.
So he was in that wing. 1985.
NAA.
National Airport Authority.
Very good.
He was in that wing. And sorry, about whom I am talking? No, I got confused. Petitioner was in IAA.
Yes.
Petitioner was in IAA. And the P. Anand Kumar was.
He will be in IAA. His induction in service was in 89.
89.
18 by 80.
In different wing. 89. Both was in existence. IAA was also in existence. And NAA was also in existence. So both of them are of a different cadre. Hierarchy was different. This was merged. Subsequently, that was merged.
1985 NAAI came.
Yes.
Then what happened?
These two organizations, IAA and NAA, were merged.
When?
It was merged in 1995.
In 1995. So when
it was considered as AAI, Airport Authority of India.
Yes.
So it was when it was merged, there were two major divisions. That is IAD and AAI NAD. That means Airport Authority of India, there was two divisions. That is IAD, International Airport Division, and National Airport Division.
This
After
AAI After merger, AAI was formed.
Yes,
In AAI, there were two
two
divisions.
division. That is IAD,
Two division, IAD and
NAD.
what is the full form?
IAD is International Airport Division and National Airport Division.
Very good.
So these were separate entity functioning under AAI, Airport Authority of India, for a considerable period. But in 2005, a unified common recruitment and promotion rule was formed.
In 2005,
Finally, it was formed.
they again merged their IAD and NAD.
No. Merging was in 1995.
No, that was 1995 merger. You
Yes.
said from 2005, what happened? From 2005, what
Yes.
did you say? Unified common?
Unified common recruitment and promotion rule came into existence for staffs across both division on 1st of February 2005.
Yes. The common recruitment and promotion.
Rule.
Yes.
So, since the petitioner was appointed in elsewhere metro division,
Now this metro and non-metro division existed since when? You opened your argument saying that there are two different divisions, metro division and non-metro division. He hails from metro, Anand from non-metro.
non-metro.
Very good. Now in 70, this metro and non-metro must have been there under IAAI then. Because in 72 IAAI was formed. After formation, now the divisions will come.
The very entry was in the year 1989.
That we are coming later.
Hmm.
When you say 72, the International Airport Authority was there.
Hmm.
So that International Airport Authority, this metro division, non-metro was there in International Airport Authority.
No, different. Metro was with IIA, non-metro was NAA.
Metro was with IIA, yes.
And non-metro was with
And non-metro was with? No, I think
non-metro
somewhere it has been confused.
NAD, National Airport
National
Division.
Airport Authority.
Division. National Airport Division.
Non-metro division merged with
Metro is IAD, Your Lordship. Metro is IAD. As I said,
metro is in IAD.
IAD. And non-metro is NAD.
So this unified rules came.
Then
What happened?
this particular petitioner was appointed in Metro Division, that is IAD, and accordingly he was governed under that rules and regulations.
Which rule and regulation? That under IAAI. Where have you stated all these
Paragraph
complicated things?
19. Paragraph 19.
My God. Now, what is your argument, madam? Then they are, we understand, broadly speaking, they belong to separate divisions.
Division.
And these respective separate divisions had their respective hierarchy. As you said, in metro, hierarchy was, it was from entry level was caretaker in housekeeping. Then supervisor, then superintendent, then senior superintendent, then the assistant manager. He was within this.
Yes,
He
Petitioner was
within
within
this.
this
He ultimately came to the post of assistant
in
manager.
2005.
Not 2000, 2000, 20, assistant general, assistant manager, he became
Hmm.
they notionally from 26th October 2012
12,
and actually from 22
2022. Actually, because from the date of
joining.
joining,
Then what about the other post? Anand was where? Anand was in the non-metro section.
yes.
So Anand has
They
got
maintaining
inside
that-
NAD.
Hmm.
Anand was non-metro, he went inside NAD. What was the non-metro hierarchy?
That I have not specifically pleaded. Let us read the
No,
Please.
you first have to understand, madam, then you can explain to me.
Lordship. To cut short the matter, I can place aptly a judgment which was between the airport authority and one instance of similar like him. A clear distinction has been made.
Doc-
Please. No, sorry, don't give that copy. It's my highlighted copy.
So that will help me.
No, absolutely on his point. There was a stagnation. Similar circumstances
This
arose.
is a
I'll give a copy to him. Let us read, Your Lordship. We will understand everything very clearly. Very clearly, we will understand.
no, this is a single judge order of Odisha High Court. It is not binding upon.
Understand, not to rely on that. We will understand the things because there are different things have happened similarly as that of
No,
this case.
before that, do you have the answer
Yes,
as regards those Mondol, those who became the senior managers, having entered much later to the petitioner. That's
Hmm,
the
yes.
that
in a different cadre, in a different cadre.
no, in housekeeping. No, in a housekeeping. No? I think you have to call your officer who deals with this.
Both of us.
Please come to please come to page 22 of his reply.
Yes, 22.
Your argument, if I have understood, is that they belong to two separate divisions altogether, having different hierarchy of
Yes,
posts.
yes.
This is your argument.
Yes, yes.
Now then kindly come to page 22 of the reply.
22 of the reply. One second.
Got it?
Yes, Your Lordship.
Kindly come to serial 3, Ravi Chandran.
Yes,
Got it?
yes.
At the top, kindly see this is provisional seniority list of senior manager. Huh? So this Ravi Chandran entry was clause made 6th of September 95. That is much later to the petitioner. So he had, now please turn to the next page.
Yes.
So where is Ravi Chandran in the list of manager HK? Where did he vanish?
It was issued on the same day, my lord. On that day, he was senior manager. And this person.
Oh, sir.
Yes.
This 30th September 2023, in respect of senior manager and manager, he has shown 3 persons
Yes,
who are younger to him, who are junior to him, who are holding higher post.
yes.
His entry was in 89, initial entry. Now these 3 persons admittedly were entered in 1995, 1996 and 1997. So they are within this housekeeping manager.
Yes.
So if they are in housekeeping manager, they have to be under that NAD which you are saying.
Yes, yes.
And if that is so, then he has been discriminated, madam.
No, Your Lordship. Now, Your Lordship, may kindly come to my paragraph 19. How I have answered that.
Page 19 of your
Paragraph
reply.
19 of my affidavit in opposition, para 19.
Paragraph
Para 19.
19.
Yes, may I read it?
Yes.
With reference to statement within para 19, the same is admitted only to the extent that the petitioner took over the charge to the post of assistant manager, housekeeping on 2/8/2022 and got the scale of pay on and from 3/11/2012. It is incorrect to state that due to fault on the part of respondent authority, the petitioner was deprived of other service benefits connected to his post. As such, he was denied of service benefit for a period of 10 years, due to which he sustained huge financial loss. The petitioner was not entitled for any such benefit as claimed by him. He cannot seek parity with others, as the respondent organization had worked as per its framed rules, and at no point of time any discrimination was made against the applicant. The Airport Authority of India, before its merger, had two separate divisions, that is Metro Division IAD and Non-Metro Division NAD. The petitioner was appointed in erstwhile Metro Division slash IAD, and accordingly he was governed by the rules regulation of erstwhile Metro Division IAD. It is further submitted that before issuance of the order of merger of both the erstwhile division of respondent organization, one of the division, that is not Metro Division NAD, with the approval of competent authority, issued one circular dated 7/5/2008 about absorption of housekeepers in terminal management discipline of erstwhile NAD non-metro division, which was merged. Here it is pertinent to mention that this process of initiation in the year 2003, by circular number such and such of 2003. As per facts reflected above, it is submitted that the above process was only for the employees of elsewhere NAA, NAD, non-metro division of respondent organization, that is before the date of merger of seniority, and it was not applicable for the employees of IAA/IAD metro division of the respondent organization, including the applicant. This was the circular. Now coming to next paragraph, your lordship will find that they have written, it is submitted that nature of duties and responsibility of each cadre are governed by the Airport Authority of India's rules and regulation. The minimum qualifying service period is given in the rules of AAI for promotion to the next grade. However, the same is subject to fulfilling the eligibility of certain criteria, that is regular service, PMS grading, clearance from Vigilance Commission, DG angles, and also availability of clear vacancy in the next grade for which promotion is to be considered. Though in some years DPC, the name of the petitioner was falling under the zone of consideration, but due to non-availability of clear vacancy in the next grade, the petitioner could not be promoted. It is incorrect to state that the petitioner sustained huge financial loss. Then it is submitted that the rules are applicable for all cadres and employees of response organization across Pan India. It is further submitted in the year 2017, keeping in view the future prospect of housekeeping cadre from which the petitioner belongs to, certain additional posts were created by order dated 2/5/2017. As and when the name of petitioner was under the zone of consideration for promotion, and whenever there was a clear vacancy available as per the rules, the same has been already granted to the petitioner. So far, our other incumbents like PG Anand Kumar is concerned, his case is not at par with the petitioner in any manner whatsoever. Airport Authority of India, before its merger, had two separate divisions, that is Metro Division and Non-Metro Division. The petitioner was appointed in erstwhile Metro Division. Before the issuance of the order for merger of both the erstwhile division, one of the division, that is Non-Metro Division, issued one circular dated 7/5/2008, by which absorption of housekeeper in terminal management discipline of erstwhile Metro Division was merged. It is pertinent to mention here that the process of initiation initiated in the year 2003, wide circular number such and such, dated 18/11/2003. As per the facts narrated above, it is submitted that the above process was only for the employees of erstwhile NAA non-metro division of respondent organization, that is before the date of merger of seniority, and it was applicable for the employees of IAA IAD metro division of the respondent organization, in which the petitioner was included. The petitioner was
Petitioner was in Metro Division.
Metro Division.
So when was this merger of rules? Merger of seniority. As per the facts
2005.
narrated to submit from the top.
Yes,
The above process was only for the employees of non-metro division.
yes.
That is before the date of merger of seniority. What is the date of merger of seniority? And it was applicable for.
It came
This
2005.
explanation, madam, is not appropriate. You are taking a plea now that no, there was no vacancy. Forget about it.
Yes,
But we must know that how you will, because 2022 his induction was in assistant manager. So in 2022 at least, because he came in 2020, his original application was in 24. 24.
Mm.
Unless, madam, you show that there was no discrimination.
for that only, Lordship, I'll just refer that judgment because I'm not able to, maybe I'm not able to express to your Lordship. We'll just read it, only for reading sake. We are not going to rely that. Let us read a similar case. Your Lordship will find from page, yes. Here, the petitioner, through this writ petition, seeks a directive of this court for integration of housekeeping section of Integrated Airport Division, IAD, into
Where
terminal.
from this IAD comes? It was International Airport Authority of India in 72. What is IAD then?
Integrated Airport Division.
Yes, but you said in 72 it was International Airport
Airport
Authority.
Authority, that is IAAI.
Very good. Then what is this? Where from this Integrated Airport Division come? This was under which then? IAD into read lately.
Let us read to understand, your Lordship. Everything will be clear.
It's very difficult to understand. Unless I get your assistance, it won't be possible. Forget about all those things. You
Yes.
give me an answer to the fact that admittedly from the housekeeping for the post of assistant manager to which he was appointed, his initial entry was 1989, whichever section you consider.
Mm.
Now, ultimately, what is the picture in 2022? In 2022, we find that he is enjoying the post of assistant manager,
But
and his juniors have gone to the post of manager.
I'll clear this and I'll come tomorrow, your Lordship. Here also, in this case also, the same thing arose. Court has observed there is certain anomalies.
Please make a chart.
Okay, and that will be better.
That will be better.
Better.
And
for an-
if you prepared that argument of yours, please give a copy to him in advance.
Right here.
So that at least we should understand now what is the case. We just cannot throw him away on the ground. Due to paucity of time, the learned advocates appearing for the respective parties could not complete their arguments. In view thereof, list the matter for further consideration on 8th April. Madam, you prepared
I'll
the
prepare the
chart on
chart.
7.
Plan.
Give a copy to, and if you have an extra copy, please give one to me
Lord.
so that I can also.
No, Lord.
Let us see whether we can finish it off on one. Have you taken a copy of this Odisha?
I'll give him. Reference to this. नहीं, condition.
I don't know. Tuesday we have many fixed matters. How it comes, I don't know.
Let it be treated as parted.
I
I have concluded. My lord has given enough time to this matter, my lord. Now, order.
I think
I
I'll.
have been fortunate to give time. Promotion matters, you have to argue, Mr. Kumar, in that slip, that way you went. You ought to have made a chart to that effect. my contention, what I want to know is, following your induction in service, the other three persons are junior. But you all three reached the post of assistant manager. I don't know whether they were directly engaged as assistant manager. I don't know. If they came in 1991, then you came in 22. In 22, what was the seniority list of assistant managers?
But my lord, the order reflect that they were promoted to the post of manager and senior manager prior to 2021. In 2020.
Subsequent to 2022.
No, prior to that, they were promoted to the said post.
So then
were given-
you ask your client
Yes, I
to
am.
bring those persons seniority list in 21.
That I will.
Whether they were directly appointed
That I have to ascertain.
or whether they have come from the seniority list. Then let us see the last seniority list.
Yes.
Then at
That
least-
my learned friend can bring.
I'll
Because
assist.
they are the authority.
Madam, I think I have not been able to be clear.
No, I understood your lordship. I will make a separate chart, how he was inducted and how they were inducted, and what was their hierarchy, both of them's hierarchy.
You don't worry about the other divisions. Let us concentrate now. He will get a favorable order if he can show that in the existing list of assistant managers when he came in 2022, by that time, earlier to that, they have gone to the post of manager.
Yes.
Yes.
So when they went to the post of manager in 2021, that is before this person came, in 2021, what was their hierarchy? What was the seniority list? Now, if he comes in 2022, then what happens? Then does he become junior in service? As he is coming into the post of assistant manager in 2022, then how do the authorities count that?
Justifies, correct. Understood.
এই নাও এটা রেখে দিও। Yes, next. Yes, Mr. Item number.
Now was there also. Just she developed a neck pain and because I'm the council for the petitioner, she has to take an instruction for a limited purpose. No one knows that. She left the course, can this be taken up on Monday? She has obtained the instruction told by her.
What is the matter about?
My client was given a termination order. We count that while entering into the service, she suppressed the phantom of a case being pending against her.
That immoral traffic act.
Absolutely, that's the case.
Now, from that you have been acquitted.
No,
Or not?
the case is at the verge of disposal. Prosecution witness have been reduced. Now probably it seeks for examination of accused under section 313 CRPC.
Very
It's
good.
almost done.
No, the termination order was of which year?
Of the year of 2024, and I'm doing my entry, I'm carrying out the job by way of an interim protection.
Given by the tribunal?
At this court,
Oh, you came to this court?
state this in this present proceeding only. The termination order was kept in abeyance till disposal, and I'm allowed to carry out my job. So I'm still in the post.
এই একটু ফাইলটা দাও। Oh, it went to Lok Adalat also.
After the interim order was granted, it went to local, I think fresh order.
Affidavits have been
Yes,
completed.
they filed the affidavit. I made a proposal, my lord, that
No, let us see the inch, when was,
22nd January 2024 order may kindly be seen by her ladyship Honorable Justice Shamba Sakar.
22nd?
January 2024. That is the day when I was supposed to be terminated. In the afternoon.
There is no 22nd.
Yes, it's here.
22nd January
January 2024, yes. sir.
24.
24. I'm having the order, server copy with me.
এই পেজ এইগুলো না একটু সিরিয়ালি লাগিয়ে দিতে পারলে ভালো হয়। Yes, 22nd. Yes, place the order.
The order which I have challenged in the present.
No, no, 22nd January.
This supplementary list has been prepared on mentioning of matter by Mr. K.V. Jaipal, learned advocate for the petition in presence of Mrs. Anjali Nam, learned advocate who appears on behalf of the authorities. The urgency is that the petition shall be terminated, shall stand terminated from forenoon of January 2024. The petitioner was given compassion appointment on temporary basis on the death of her husband. At the time of applying, the petitioner filed in the attestation form in which she did not disclose about the presence of an alleged criminal case. When the petition was being considered for confirmation in the post, the
No,
petitioner-
this is what department?
it's PSN, Bharat Sanchar Nigam Limited.
Bharat Sanchar Nigam. Acha. At the time of petitioner filed in there, did not disclose pending. Acha, being confirmed. Petition further also put. She was being she had implicated and surrendered the. Acha. Short point is whether the author is also. So your the concession you are wanting is that you allow the inching order to continue till the disposal of
Yes,
the.
if the jurisdictional magistrate hold for the conviction, Lord,
Suppose he does not, if he holds you guilty,
then fine if at all, because there is a provision for imposing fine. It's not an offense of moral turpitude, Lordship. If suppose ultimately.
but
so-
how can we dispose of the writ?
But what I pray, Lord, that till because it's a verge of disposal, criminal case. So till the criminal case court decides the issue, Lordship, this order has to be made operational, interim order. Because again,
It is already in operation.
Yes.
You are working there.
yes,
But how can we dispose of the petition?
everything can be left to the final decision of the magistrate court, Lordship.
No,
Because so
please
far,
give a thought
and
to
the
it.
defense lawyer there. So far as prosecution evidence is concerned, they miserably failed. But what would happen, nobody knows, Lord. What judgment would be passed, but as a.
But what order do you want me to pass?
Lord,
I have to set aside the termination then.
My lord, I say, Lordship, it can be revived if I am held convicted. And that too for a, I've been sentenced to jail. Because if its fine is imposed, my lord, then Lordship, this has to be made little easier, Lordship. Because it's a immoral charges.
No, the termination order is under challenge.
I'm not.
You got an interim protection. That interim order, no steps have been taken by them to vacate that interim order. They have allowed you to continue.
My lord.
Now, then they are, if we dispose of this petition, then either I have to set aside the termination
My lord.
or I have to uphold the termination.
My lord.
This is my option.
My lord.
Now you tell me how can I
Makes
do
it
that?
one thing, Lord. The third option would be, my lordship, let the writ be kept pending. The criminal matters is most probably posted in the end of this month.
No, it cannot be disposed of. How we can dispose it of?
Because I have put forth a proposal that till the criminal court decide the matter, Lordship, I may be allowed
What
to.
she has taken
She has taken, I'm told, she just left the court premises. And she developed a neck pain, Lord, just she left the court premises. I was informed to inform this court.
No, Mr. Jabal, let us be honest. We cannot dispose of the petition extending the interim order till the disposal of your criminal case. What we can do is we can set aside the termination.
Mine.
Now, if we set aside the termination, that they will not agree. If that they do not agree, then we have to decide either one side or the other. We must say.
So far as my knowledge goes, the interim order is made operational till the month of June 2025. It's extended time to time, The last section, by virtue of last section, it's operating till June 2025. Let this matter be taken in the next circuit. By that time, Lordship, I can, the logical conclusion will be rendered in a criminal matter. Then I can place these facts. While pressing this application, those facts can be placed.
You have exchanged your affidavit.
Sir, affidavit opposition has been filed, Lordship. I have nothing to add. What I have said, want to say, I have said in my writ petition.
So the interim order is there till 31st of March. It has, no, it is till June,
June.
15 June.
My lord.
He doesn't have children.
Yes.
The allegation against her is she has, what is the allegation? Her house was utilized.
Her house was. There were several tenants. The tenants are not under the control of landlord.
Not to take, you take the instruction and come back.
Let it come on Monday, left in presence of police.
8, 9, 10, same.
No, those are.
Yes, দেখো তাহলে non-on-board. Yes, any matter where both sides are here, you can finish it off. Any matter, sir.
Okay.
9 থেকে 17 ডেকে দাও। Solving
Item number 9, 863 of 2023.
Yes,
I am representing exponents.
yes, what is the matter, Mr. Kumar?
I am not there, but I want to mention, but
9 is Mr. Vijay Kumar. Oh, you are there, sorry. Yes. What is the matter about?
I filed a petition earlier before this honorable courts. This honorable court directed the authority to consider the representation. That was turned off. So,
Representation for what?
except the premium. Premium was given to the petitioner. So it was not recorded. The license was given to the petitioner, but the premium was not accepted by the administration. So I filed a writ petition. First of the premium.
No, land was given to you
License was given to my client. But
for enjoying the land.
Which is-
Now, the premium which you will have to pay for such grant
Yes, yes.
was not accepted by the authorities. Then what happened?
I filed a petition with the honorable court. It is honorable direct authorities
To
consider the
consider.
representation.
Now, what they have said?
They have said, my lord, when you come to my lord at page number 21. In the court,
Yes, just give me 2 minutes.
they relate certain documents. It was not supplied to me in the course of hearing, first point. And second,
Just.
Right.
So what is the wrong in this
I
order?
mean, submitting. I know last paragraph,
Yes,
page number 21.
21 last
Yes.
paragraph. Survey conducted, it was found.
And whereas the course of the hearing, assistant commissioner was directed for giving the factual report.
Hmm.
They relied upon this report. They relied upon this report. This report was given to me.
I see. Where is that you have annexed?
It's not given to me.
It was not given to
It
you.
is not supplied to me, first one. And second point, my lord, they have.
Now,
said-
as per the inspection, what was found? That you applied, it was found total occupied land was 372. in survey number 2, whereas he was issued only for 250.
Yes. Second.
To show your license, what was the
Yes,
allotment?
second point is that, my lord.
So total area was 372, you were given 250.
My lord, can you see, my lord?
Now out of 250, you sold to 2 persons,
Not
150.
sold, my lord, it's only allegation. I am disputing it. Where is the document to show I sold the land? Let them produce the document I sold the land. How can I sold the land? First point. Second thing, my lord.
Just a moment, 372 was the total land
My lord,
in survey number 2.
my lord.
Now they are saying 188 was sold to one sound,
So and so person, yes.
reported to the, and he is occupying the same by constructing an RCC. The remaining 184. So 188 and 184 comes to how much?
Oh, it's about.
আচ্ছা 12, 18, 16, 17, 370.
My lord.
That is the total.
Totally.
Remaining 184, how can that be? The total area is 372.
Yes.
Yes, Mr. Shibbalan?
Your Lordship,
What did you say in your affidavit? কি বলেছো?
proposition we have filed, the same change which has been stated in the order.
What matter? Why? You have repeated you have quoted the reasoning what is yes.
My lord. What is there in the order, it has been.
So how did you come to this finding that he had sold? Did they appear at the time of inspection?
My lord, a report was called from the surveyor,
Hmm.
settlement and.
So you bring that report.
Yes, I have brought the original because there was a direction by this honorable court to bring the record. I brought the report.
Show it to your friend.
Yes.
Show it to your friend.
Yes, sir.
What did you find in the report, Mr. Shiva?
That it comes to know that out of such and such area has been sold to one Sanmugam, reported to be a purchaser.
Has been alleged. There's no document to support that. I think.
So why will the writ court interfere?
The first thing, second thing, my lord. Second point I have taken is that, my lord.
You have sold it.
Not
And
sold.
your contention is I have not sold.
Not sold.
They are saying it has been sold. In such a
But it is
dispute,
upon them to prove.
very good.
Yes.
But then you go to the appropriate forum, sir. I will not prove that.
My lord.
I thought the burden is upon them. They will establish.
Yes.
Now it will continue as it is. They will not receive the premium. To get it solved, you have to declare and take a right now. This can never be solved in writ petition. You will say I am not sold. They will say I have sold. So you get hold of the person making a party. Then you.
It is for them to prove it that I have sold. Merely making allegation that I have.
Sir, license. They have given the license. They are not accepting the premium.
Yes.
This way it is. So what is being happen? The license is not being regularized.
Yes.
The license they have not cancelled it yet.
No, not.
They cancelled it. They are not receiving. So if somebody is there, if the allegation is that somebody you have sold, then somebody must be claiming right on that property. No, we cannot now ask those 2 persons to be added as
But
party.
I can't file affidavit. Nobody is claiming right, my lord. Nobody is claiming. I am the exclusive person on the particular piece of land. I let out rent. I'm getting the rent from those properties. That is different. But I have not sold it.
No, who is this gentleman, Murugutam something?
There are one Rita, R Rita and one R Sanmugam.
So you ask your field inspector to know
Yes,
that they are occupying the.
Yes, this is the report as well as the map.
So why didn't you annex it to your opposition?
Yes, sir.
You should have annexed. He would have left light to that. That report is there.
Yes, I can trace it now to before.
You take the trouble to go through it. Why you are shifting the burden on me? Huh? Please with the file. Now you read and do whatever you want. Sunday, Monday, holiday, you go through the report and come back and tell me. Not today. Chalo, take a break.